Yes.
My lord, may I make on submission?
One by one, one by one.
Yes. What is the urgency? Slightly loud. Use that mic.
Sir,
Use that
I-
mic.
The partition suit, the division is ordered, the commissioner is visiting the property, for division of the property.
When is the
What-
date? Just
Ma-
one.
Twenty-fifth, he is visiting the property for division,
For division, huh?
division.
He's just give a report to the
No,
court.
no, he would submit the report, before that,
Right.
before that, because if the division is effected, by carrying out the acceptance of the report, very purpose would be defeated.
When is the date of hearing?
25th,
Where?
25th Feb before the.
For the
law.
court, just take it.
24th, I would, 24th,
We will see it. We have to see it.
please,
Just give the mentioning.
please,
We'll just take it.
The lordship
Just
is
1
trying
minute,
to-
please.
Pardon,
Is there any caveator? What is this?
no,
Huh?
no caveat.
No caveat. Is it pending matter?
It's a fresh matter, pending, not posted, since 6 months.
But it's registered, na? And is there any caveat? Caveat.
No caveat as such.
Just give it, let's see.
The lordships kindly, my lord.
Just 1 minute.
Two appeals.
Just 1 minute. Let's do, just call the, this one.
Sir, would you allow us? Sir, I was. KVA service ಮಾಡ್ಬಿಟ್ಟು ಕೊಡಿ sir. KVA service.
No objections, no caveat.
Please, I'll give it to the truth.
Yes, give it. Yes.
Lordships kindly, my lord. Two RFAs were listed on 12th, my lord. 11th, my senior went to London, my lord, and he was instructed to take a date in all the matters, my lord, which it appears in his neck. I came and took a date, my lord. It was a senior engagement, my lord. My sincere
It was,
yesterday, my lord. I mean, on 12th, my lord.
now what is the date now?
Now date it has gone to April, my lord.
File an early hearing.
My lord, we already filed application and all. It was listed, but unfortunately by due
You're
to,
right. Today date is of April.
April, my lord.
That's right. File an early hearing. That's how it should be. That's right.
Please, my lord.
Anyone appearing for the other side?
No, both both the parties are waiting on Friday. The
Do-
respondent as well as the petitioners, my lord. It was senior engagement matter, my lord. Unfortunately, I took a date morning.
I'm telling you something, you should hear it.
Please.
Please file an early hearing
Please.
application and get it listed.
Please, my lord.
You want advancement of the date?
Please, my lord.
We'll do it.
Much
Come.
Yes, my lord. Suit for declaration injunction, my lord.
Huh.
The respondent number 6 is date, my lord. I bring LRs and on record, my lord. Can I take up next week any date for me? my lord?
What do you want?
I want posting memo, my lord. The LR, I file LR application, my lord.
Huh?
Bring LR on record, my lord.
Huh?
The purpose only
Is this is a memo for listing of LR application?
LR application. my lord.
Okay, just give it after 2 weeks in the first week or second week of March.
Sir, 1 minute.
Is there any other side also?
There is-
No one is appearing on the other side.
No.
Notice issued,
Please, notification, my lord, but otherwise not any.
no representation. Okay,
Sir,
yes.
My lords, 2022 commercial appeal, it has not come up for admission, my lords. Any
What are
date,
you doing for 3 years?
my lords, we've moved earlier.
When?
Senior engagement was there and there was
When was the early hearing moved?
in 2023,
And where are we today?
25, my lords.
And what were you doing?
Any
What
date,
is the urgency now?
just for the admission
Give
purposes.
it, ma'am, somewhere in March.
I've served
Is
a
there
copy
any
on the other
caveat?
side. I've served a copy on the other side.
You will do one thing. You will take an acknowledgement, we'll give you a date, take an acknowledgement, then give it to the court office.
I've taken an acknowledgement on the.
Not now. After giving the date, you will ensure the date is notified by, to the opposite counsel.
Yes, ma'am.
Okay, then only we will. Otherwise, the appeal is no objections?
No objections.
Yes.
Lords, 2012 arbitral award has been set aside, my lords. There's one more connected matter coming up
Because it's set aside,
in November 2024, my lords.
November 24.
There's one more connected matter, my lords. It has been listed on 21st this month, my lord.
From the same award,
Same award, my lords. Same judgment.
same
Same
judgment.
judgment, my lords.
Just take it, ma'am. Have it on that day. Is
I
there
have
any,
served-
are there any objections?
No, my lords. I have served on the other side, my lords.
But objections?
Lords,
Objections?
nothing, my lords.
All cleared?
Yes, my lords.
Yes, ma'am, sure. All clear. Have it on 21st.
My lord.
Yes,
My lord, the student was not allowed to take examination. He has not got admission to the law degree.
what is this? Is it a writ appeal?
Writ appeal, writ appeal.
What, which,
Unit-
when did you file this writ appeal?
Writ appeal is 2022, 23.
23 writ appeal?
Yes.
What is the urgency?
Urgency, the boy is without examination, without schooling. He has not got admission. He is still there at the home only. He was not
When
admitted.
are the exams?
Exams, it was in 2020.
What are you mentioning? Have you filed any application or what are you mentioning?
Application is moving the memo, this
For,
for posting. For
why
here,
don't you file an early hearing?
my
File
lord,
an early hearing.
my lord, I am from Mysore. I have to come here. Very multiple problems is there for me. That's why I just.
The appropriate should be an early hearing application. It's a pending matter. Then take it, man. Just give a date. We'll give you a date. Come on that day. Fine, just give it in first week. We'll give you a date. You come on that day. But is there anyone appearing for the other side?
Other side is there.
You have to inform the council there.
Yes,
All the respondents who are appearing.
yes.
You have to take their acknowledgement. Ma'am, just inform him. Tell him.
Sir.
Just tell him.
Lordships.
Just.
Yes.
Yes.
My lord, writ appeal 497 of 2024, my lord. In this appeal, we have challenging the summons issued by enforcement director. Your lordship reserved the matter for judgment. We are filing written, sir,
Oh, this was that where
Yes,
Mr.
ma'am.
Patil had. You didn't file it on Friday.
because of.
Who was briefing Mr. Kamath?
Mr. Madhukar Deshpande.
Oh, Mr. Madhukar. But have you given a copy to them?
Please, my lord.
Have you given?
Please, my lord.
Just take it, ma'am. And you have taken a receipt,
It is, no.
but you have given, na?
Please.
We take it. Yes, Mr.
Yes, sir.
Kumar.
Lordships, this is a fresh writ petition challenging the order passed by the learned Central Administrative Tribunal directing the railways to grant notional increment to the respondent, my lords. Respondent was penalty was imposed, reduction of lower stage, which he has not.
When was the order passed?
Passed on 25/7/24, 4 months time was granted, my lords. December it ended. They have filed the
Contempt?
contempt. 3/3 it is listed, my lords.
Officer has been summoned.
Notice has been issued, my lords.
Let him go there. What is the urgency? Tell us. You don't take any action for so many.
My lords, there is a penalty imposed in the year 2015. He has not challenged. Learned cat did not go into the matter of
When is the date before the
3/3, my
tribunal?
lords. 3/3. 3/3,
Third
3rd
March.
March. I have complied all objections also, my lords.
Date.
Some date maybe.
Who is the other side?
No, not yet. Notice has not yet been issued.
Caveat?
No caveat. Some date.
My lord, this is a 2021 RFE, my lords. It's coming up now. It's a fresh matter. We've recently entered,
What is the urgency?
my lord, the beneficiary of the will, this is a will challenging the impugn order, my lord,
But it has not been listed.
not been listed, my lord.
So just give it, ma'am, somewhere. But all objections cleared?
Yes, my lord.
Fresh regular appeal, my lord.
Okay, yes.
Fresh regular appeal. Suit for partition is rejected, plaint is rejected for want of cause of action. The reason assigned is my grandfather did not seek for partition, my mother did not seek for partition. So I am also not entitled for partition. There is no cause of action. Now, after the dismissal,
So
rejection,
what is the urgency today?
there is threat of alienation. They are entering into agreement.
Just give it after first or second week of March. All objections cleared?
All clear, ma'am.
No caveat?
No caveat. Please.
That's it. Any other mentioning?
My lords, fresh RFA.
You want to, fresh listing?
Yes, yes.
Yes.
My lords, RFA of the fresh filing, my lord.
Just use the mic, ma'am.
My lords, fresh matter, my lord.
Yes.
Regular first appeal. Suit is for
declaration and injunction, my lords. Suit of the year 2006, defendants appeal, my lords. The respondents are trying to take steps to change the revenue records based on the impugned judgment in increment.
Pardon?
The respondents are taking steps to change the revenue records based on the impugned
Your
judgment. and
decree.
decree,
When
my
did you
lords.
file this appeal?
2025, my lords, fresh appeal.
20?
2025, fresh appeal. my
So
lords.
when is the date? What are the proceedings initiated? Have they initiated any proceedings?
The plaint was rejected, my lords. The suit.
Plaint was rejected now. Was there any stay below?
No, my lords.
Just give it after 2 weeks, March or so.
One matter for withdrawal of the appeal minutes, RFA.
Huh.
Settled out of court. So intending to
Immediate to the
withdraw the
WhatsApp will proceed.
first appeal.
After.
We'll have it,
Please, any date.
just have it in March or so. No, but you have to inform the other side.
This has been not yet issued in this.
No caveat, nothing. But it's a registered RFA.
Registered RFA notice.
Was it listed for hearing? No, then what do you want?
They want to withdraw the, appellant want to withdraw the appeal.
But has it been registered?
Has been.
Oh, 20, this is 23 RFA. But notice has been issued. No, do one.
Have instructions that notice has been not yet issued and they have not appeared in this.
This is 23 RFA, ma'am, just check up. Just come back after lunch,
Please, please.
after lunch. And don't say, just check up the order. Just check up the order. Yes, any mentioning? He is saying, ma'am. Mike,
RFA matter, my lord. 21, RFA matter.
what is the urgency?
Senior citizen, my lord.
Huh?
Senior citizen.
So when did you file that?
21, my lord.
20?
One matter.
File an early hearing. File early hearing. Yes, come. Yes, what is this?
It's mentioning for an adjournment. Adjournment, for an adjournment.
Which number?
Serial number 35, my lords. I appear for the respondents in that.
Who is the other side?
My lords, the other side is present.
I
My lords,
appear for
these
the
are those atria matters, my lord, that share transfer, there was an 100.
Ah,
The
this is
commercial,
This is an offshoot of those.
no, that is an offshoot of this.
Acha.
This is the, my lords, if there the trial court is still not passed orders, it's now posted on 18th.
Oh, it's a.
Then my request for 5th of March, my lord, it's convenient to both sides.
See, there is one, notice need to be issued.
35 minutes.
These are three connected.
Open it, open it. No, it says a notice to be issued to R5 to R7. Who's R5 to R7?
So both the sides. So now do one thing, there is one service need to be effected to R5 in 165.
Those are, my lords, the appellants in the other two matters. My lords will see 35 says
Please.
Baboon Investment.
We want to know who appears for R5 in 165. We will mark the attendance.
Yes, ma'am.
We'll dispense with.
This one.
Very well. No, see, then we will say so this, say just at the joint request of the council for the parties. Re-notify on, just give it, ma'am, we'll have it in June.
My lords, I have only one request. Ma'am. If it is possible to have it on 5th of March, I'll just tell my lords why.
Why?
My lords, what has happened is that the argument that they are raised before the trial court is that the interim orders which are passed in serial number 35 is sufficient for them to initiate further proceedings and take it to its logical conclusion. Whereas our contention is it's not so. The interim order is subject to
Why
further.
do you want 5th?
My lords, it's convenient for both the senior
Very
counsel.
well, 5th of March. In the meantime, the counsel for the appellant in COM 165/2024 shall serve the respondent number 5.
My lords, respondent number 5 is the appellant in 209.
When we are just simply asking
Please.
who is appearing for the appellant in 209.
I appear for the appellant in
Very well,
209.
we'll
I'll
mark
take
your
notice.
attendance for respondent number
Please.
5.
Please, my lord.
Just say this 30, we'll just cut that. Though the service on respondent number 5 is still incomplete, comma, so and so. Then the counsel appearing for which appeal?
209, my lords, the main appeal
In
35.
209. of 2024 states that she shall accept notice for respondent number 5. That's right?
Please, my lord.
In view of the submission made by the counsel for the appellant, counsel for the respondent number 5 in comp 165/2024, the notice to respondent number 5 is dispensed with. Full stop. Then at joint request, then say joint request 5th of March. Next.
Serial number 2 also, my lord, is the writ petition.
So what do you want in 2?
Same, 5th of March itself. my lord.
At the joint request of the counsel for the parties, re-notify on item 2.
Yes. Interim order needs to be just.
The joint request re-notify 5th of March.
Please, my lords, interim orders may kindly be extended in the commercial appeals,
35.
serial number 35.
Okay, ma'am, in 35, just show us the last order.
Whichever I will give it. No, last order will be extended.
Just say in whichever case the interim order subsists as on date, the same shall continue to operate till the next date of hearing.
Obliged.
This would be in 35, ma'am. 2 at joint request, same date.
Lord, serial number 15, my lord, I appear for respondent. But my learned friend on the other side is also here. I've informed her. Lord, this matter, in fact, my lord, was heard before your
Oh,
lord.
you said?
15, my lord, 15.
Yes.
My lord, we will file our list of authorities online, not been able to do
We'll
that.
just hear it. We'll try to hear it. Let's see.
Lord, some inconvenience today. That's why I requested my learned friend.
Why didn't you file it? Tell us.
My lord,
We'll hear it. Just wait.
please.
We'll just take up. Next.
Serial number 47, my lords, appear for the respondent. The arguing counsel is unwell today. I've informed the appellant they are present on VC, my lords.
I appear for the appellant in this matter, my lords.
Who appears? You appear, ma'am, for the
For the appellant, my lords.
at the request of counsel for the respondents on the ground that the senior counsel is unwell.
Arguing counsel.
The arguing counsel is unwell. Re-notify. Just give it.
My lords, another, if I may make a submission, my lords.
Yes.
My lords had directed us to file our joint convenience compilation and synopsis online. However, due to a technical issue, we're not getting the option for e-filing to the High Court. If there is any other way in which we may submit the scanned copies of the documents, everything is ready, my lords, but because of this technical glitch with the website, we've not been able to file it.
Because of?
There's some technical glitch with the portal where I'm only getting the option to do e-filing through
Ma'am,
to
why don't
district
you
courts.
take this thing? Why don't you go to the e-Seva Kendra?
Please, my lords.
That would, I think they will facilitate the filing of it. Just make an attempt, otherwise you mention it.
Please, my lords, I will do that. May I request for a short date either next week, my lords, or
Not possible, ma'am.
the shortest day is possible as per my lord's convenience.
We're just giving a date. What is the date, ma'am?
10th of June.
10th June, ma'am.
If any time in April or March, my lords.
Not possible, ma'am. And we have a recess in May. Let it be so. Okay?
Please, my lords.
Thank you.
My lords,
Much obliged.
kind indulgence, my lord. Item number 44 in this case, my lord. This matter was based on the application filed by the earlier in this. What was fixed for today. There's a small inconvenience for the senior counsel, but this matter is led by senior SS Naganand.
Who is the other side?
Other side is, my lord, is in VC, my lord.
Present, my lord.
No,
For
you
R2
appear
and
for
R3.
whom?
For
I am
Unikrishna,
from respondents, my lord.
Who is for the union?
Unikrishna M, my lord. I'm present on his behalf.
You just say that at the request of counsel for what you are appearing for whom?
For respondent 1 to 4, my lord.
1 to
1 to 4, my lord.
1 to
4.
1 to 4.
Yes, my lord. Whereas this matter pertains to land acquisition of 1941.
At
In
the
a short
request
date,
of-
my lord, we have filed an application also.
At the request of counsel for the respondents 1 to 4 for an adjournment which is not opposed, adjourn to.
Short date, my lord.
We will give you a convenient date.
Grateful, my lord.
Lord, serial number 34.
9/6, sir.
I know. You say 1 to 4 or 1 to 3?
1 to 3, my lord. I'm sorry. I'm sorry, my
You
lord.
should be clear.
Sorry. 1 to 3.
1 to 3.
Grateful.
No 4.
My lords, serial number 34.
Yes.
I appear for the respondents, my lords. My lords, as per the previous order, my lords had directed both parties to file written submissions and for the appellant to file the paper books, my lords. My lords, we have received the paper books. My lords, we just request for a week's time to file our written submissions, my lords.
Which number you said?
34.
I'm the appellant.
Yes.
Paper book has been filed, my lord.
Huh.
I are ready with the synopsis, subject to my lord's convenience, since they are requesting for a date.
The paper books be filed within how much time?
Paper books have been filed.
My lords, paper books have been filed. We request for a week's time to file our written submissions, my lords, as per the last order.
We have been informed that paper books have been filed in the registry. Full stop. The counsel for the parties seeks and allowed how much time? 4 weeks to file their written submissions. Adjourn to.
Need it in April, my lord. Short-
We'll see. Just check up now.
Short point on interpretation of few Supreme Court judgments.
16-4.
Great.
Obliged.
Lords, in serial number 20, my lords, for the appellants. For respondent number 2.
Which number?
20, my lords. There are 4 matters, my lords, listed in 20, 21, 22 and 45, my lords.
That's right.
I have informed the other side, my lords. The reason why I'm taking adjournment is that, my lords, we have sent draft rejoinder to the department and we are awaiting approval of the department, my lords.
This is rejoinder to your delay application, reply to the delay application.
Please.
You have not filed the rejoinder?
No. We have sent the draft to the department, my lords.
Just say
The
that
concerned officer is
counsel
not
for the
available.
appellant seeks and how much time you want?
Yes, sir. Week's time may be granted.
Week's
2
time
weeks.
to file rejoinder affidavit to the reply filed by the respondent number 2. Respondent number 2 to the application seeking condonation of delay. At his request, adjourn 2. This is 20, 21 and 22.
And 45. 20, 21, 22 and 45. 4 matters are there.
45 also. Give the date, ma'am.
20th March.
20th.
Grateful.
Yes. Come.
Serial number 11, my lord. There are some steps to be taken. Maybe
Pardon?
There are some steps to be taken, my lord.
For what?
Service of notice, my lord. It may be kindly taken up anytime next week.
I'm appearing on behalf of the respondent in COMAP 248, my lords.
You said 21.
11, my
11, my lords.
Let notice be issued to respondent number 2. Let fresh notice be issued to respondent number 2, returnable on
4-6.
lord.
Is it 2 to 4 or only 2? Ma'am, show us the other matters, ma'am. 11.1, 11.2. Is it only 2 or 2 to 4? Just say 2 to 4.
4, my lord.
2 to 4. Okay, let it be. Next.
My lords, may I mention a matter for listing? This is
Yes, which matter?
Commercial Appeal 166 of 2021, my
Is it a
lords.
pending matter, ma'am?
It is a pending matter. The appeal has been admitted, my lords. It was
File an application for early hearing.
Please, my lord.
Better. Yes.
Serial number 4, my lords. We are for the appellants. We are filing a memo for withdrawal, my lords.
Just wait. We'll come back. We'll call the list.
Number 1. Dilip.
I'll take fresh
Number
steps.
1.
A week's time, I'll take fresh steps.
Let fresh notice be issued to the respondents returnable on.
I may be permitted to take out and summons along with that.
Let fresh notice, including hand summons, be issued for service on respondent returnable on
5-6. Serial number 2 adjourned. 3. Serial number 3, Sri Chidananda.
For the respondent, KV Tarigos. Office appellant, my notes.
Yes. Yes.
Challenging the decree of the suit, Your Honor, wherein one of the partner had filed a suit in the name of the firm as against managing partner, inter-alia claiming that the firm is the absolute owner of the property, which was purchased in the name of the appellant, who was the managing partner. Now, the trial court had declared the suit, my lords, on the holding that the property in reality has been purchased on behalf of the firm. Fact remains that no single penny has been paid from the account of the firm. And even then, the trial court has chosen to declare the suit, my lords. There is total extent of the property is 5.90 acre, out of which an extent of 2.30 acre has been sold to third parties who are some of the respondents herein, who in turn have filed RFA number 2256 of 23, wherein this honorable court has already passed an order of stay of the impugned decree, my lords. My humble submission before this, my lords, is
No, when was the order passed? Is the decree stayed?
decree stayed in connected matter, my lords.
In the connected matter, who had filed the appeal? Against the same decree?
The same decree, my lords.
Who had filed that appeal?
That is filed by respondent number 3.
Respondent number?
Respondent number 2.
When is that appeal coming?
In fact, it was connected with this appeal, my lords. It was clubbed, but unfortunately, my appeal was dismissed for non-prosecution for non-compliance earlier. It was restored during last occasion.
So we'll have it, no, is there any date in that appeal?
No, my lords.
And you must get it, that appeal along with this. So once there is a stay, I don't think, then why did you move
No,
the
that is
memo?
stay is only in respect of their right is concerned, only in respect 2.30 acres.
You appear for?
Lordship, in this appeal also, there is office objection. They have to comply
It
that.
has been complied with. It has been complied with, my
No,
lords.
we have 4 objections.
Court fee has been paid, my lords. Copy has to be served on the side. That has also been
Date
done,
of
my lords.
events to be stated, marking of stating annexures, other papers to be stitched, 2 IAs filed for the same relief, clarify.
I think
Do
it has
one
been
thing,
complied.
clarify remove the objections.
Lord, as far as that concerned, that is complained, my lord. Fees is being paid in the 20th November.
Very same day it was paid.
Same day.
On the day of restoration.
No, have you filed, have you just show it to them, these objections? Just have a look on these objections. Have you cleared it?
Synopsis, marking. ಮಾಡಿದ್ದೀರಾ? ಆಗಿಲ್ಲ? Sure.
Lordship, one submission, Your Lordship.
This is not completely digital.
Has to be over.
We have this.
2A same relief on them, what does it mean? 2A same relief on them?
So you remove the objections.
Has been complied with, my lords.
Complied with?
Yes,
Very well, we'll note it. Now, what do you say?
So Lordship, kindly connect both the matters, and after completion of the office objection, kindly post the matter.
Office objection complied with. My
No,
submission
we will
before
record
my lords is.
That is not an issue.
Now,
Now, what does the,
there is some urgency in the interim relief sought for, my
what
lords.
is the decree? Let's see, what
Decree
is
is,
the nature?
by
of
way
the
of decree, the property which was standing in the name of the appellant has been declared as a property of the firm, to which I myself is the managing partner. It's a case where, my lords, one partner files suit against managing partner.
Who purchased the property?
I purchased property in my
purchased the
individual
property.
name.
Very well.
And very interestingly, very same partner who has filed a suit, he himself was a GPA holder to the vendors. He himself executed the sale deed. After lapse of 13 years,
What is the interim relief you are seeking?
I am asking for stay of the impugned decree.
Stay off?
Stay of the impugned decree.
Then what will follow if it is stayed?
No, obviously, there was no interim order throughout. Before the trial court, there was no interim order against
For the
me.
nature of interim order before the trial court?
There was no interim order.
There was none.
There was no interim order throughout.
And what is the interim order passed in the connected appeal?
Connected appeal decree has been stayed insofar as the appellants therein is concerned.
To that extent.
Only to that extent. In fact, it was passed earlier, to be very honest, it was blanket decree of order was passed, thereafter it was
Now-
clarified by the
now,
honorable High Court.
let's see, come to page 96. So the person who filed the appeal
Yes,
is, who has filed the connected appeal?
there are different number, three. Different number three, my lords.
Defendant number 3.
Yes,
So there is a stay here.
there is stay insofar as different number three is concerned.
Okay. Now you are
I am the respondent, defendants in 1 and 2.
R.
before the time.
Prakash.
Yes.
You
R.
are
Prakash
1 and
sir.
2.
1 and 2, my lords.
1 and 2 defendant.
Yes,
Okay. So you executed the sale,
Yes, my lords. Yes,
purchase the property,
yes, my lords.
which is now sought to be treated as a firm's property.
Firm's property.
And you have been directed to,
No, I have not been directed.
you have not been directed, but the sale deed has been set to naught.
Yes, ma'am.
Okay. What do you say?
Lordship, the proxy counsel, the senior of the case is not in station, your Lordship. Day after tomorrow or tomorrow, your Lordship.
Have they filed any execution?
Lordship,
They have not filed execution.
No, there is no operative decree in the sense to file execution.
There is no operative decree. You are right.
So as to file
But there is a
execution.
declaration.
It's a declaration to
Who
the
is in
effect that
possession?
we are in possession.
You are in
We are
possession
in possession.
and maintain status quo. Maintain status quo.
But maintain
regard
status
to
quo in the
title-
sense, Your Honor. It will continue to be in the name of,
Is it, what
status-
kind of a property is this? Is
it's
it
a vacant
built-up
land. It's a vacant land.
Vacant land.
Money other than-
So
There
you
is a,
will,
there is a house, farmhouse, wherein I am residing.
you will maintain status quo with regard to title, possession and nature of the property.
With due respect, my lords, it will continue in the name of the firm if it is in status quo. If it is a status quo, it will continue in the name of the firm because of the impugned decree. Now the firm has become the owner of the land.
1 minute, please. We see that is the finally need to be decided in these appeals,
Understand?
right?
But I am ready to give an undertaking that I will not create any interest in the property.
You are in
If-
possession.
I am in possession.
We are saying status quo. That means you'll continue to be in possession. Getting? On the basis of this declaration, suppose the title gets changed,
Yes,
then what will happen? Third party rights gets created.
yes.
So we obviate such a situation, we are saying. Getting the point?
I got it, but
What?
I would request the applicant to grant me out of stay. If not,
Stay of what?
stay of the impugned decree, my lords.
Now then what follows?
Of course, it will revert back to
Then
my
this
name.
sale deed, the declaration has been stale deed, gets stayed.
Yes, but I give an undertaking to the effect that I will not create.
You
any
don't
interest.
understand what is the difference between that and this. Getting? Just say this appeal has been listed before this court today on the basis of a memo moved by the counsel for the appellant. Now, who appears for the respondents in this?
Srinivasa,
You appear for whom?
on behalf of Srinivas, respondent 1.
Respondent
1.
1. That is the projects. You should see the memo parties, please.
The lot projects.
And who appears for 2 and 3? 2, 3, 4.
234 on the earlier occasion, the council appeared for the connected matter here it appeared, my lords.
2 notice has gone in this appeal.
No.
Let notice be, say notice. So and so accept notice for 1, respondent number 1. Let notice be issued to respondent number 2, 3 and 4. Returnable on. Give a date in. Give a date in. Given in April, man. We give in April.
16.
Telangana Council for the appellant states that even the respondent number 2 has filed an appeal against the
yes.
same
Yes,
judgment decree dated 5/9/2023 in OS in OS /201/2019, where a stay has been given insofar as that appellant is
Yes,
concerned.
RFA number 2256 of 23.
That being RFA number
2256 of 23.
2256 of 23.
Yes, ma'am.
Full stop. He presses for the interim application being 1 of 23. Suffice to state that the parties shall maintain status quo with regard to the title, possession and nature of property. What is the scheduled property?
Scheduled property is the land with building, my lords.
Where is the depiction here in the appeal?
Then the decree, my lords. Page number. Page 109. I'm sorry, page 106, my lords.
Now, we are concerned with a scheduled property or all?
All properties.
All properties.
Yes.
In terms of scheduled properties, A scheduled properties, B scheduled properties. That's it.
Yes, yes, ma'am.
Pages, just said it's pages 106 to 110. 110, na?
Yes, my lords, 110.
110 of the paper. Just said that as depicted at pages 106-110. Okay, till the next date of hearing.
I make one submission.
Yes.
My house is situated, position may can be noted, my lords.
Pardon?
I'm in possession. Could it be noted?
We'll note it. He presses for an interim, he presses the interim application. He states that the appellants herein are in possession of all the scheduled properties.
All the schedule, except 230 portion. Except which are sold in favor of respond number 2 even.
Which is
File
that?
detailed objection, just kindly give 2 days, your lordship.
No minutes. 2.30 acres out of 5.90 acres has been sold in favor respond number 2. Except to that in rest of the
Come to
properties.
106, please. Now tell us which properties you are in possession, which are you are not. Or otherwise we'll do
Sir,
one thing.
In 106, there is last line, my lords. 106 last line. 2 acre 30 cents. That is in position of respond number 2, my lords.
That's right. And you may be not concerned with the properties where the respondent number 2 has filed an appeal.
No.
You're not, no?
No, no.
Now,
Because I already sold it.
which are the properties with which you are concerned here?
Sir, I am concerned with all the property except
We'll do one
2.30
thing then. We'll
2.30 acre, which is subject matter of 2256.
come to 106.
Yes, my lords.
Which number?
Last line, last but one line.
Which last line?
Last but 2 lines, my lords.
106.
2 acre 30 cents.
In total, 2 acre 30 cents.
Yes, my lords. I'm sorry. A schedule, respond number 2 is in possession. In total, 2 acres. B schedule, I'm in possession. B schedule, I'm in possession.
See, we want a clarity, you know.
No, sir. No,
And let's be very clear. We go by the submission made by the council.
yes, my lord. A schedule, they are in possession.
We expect that the council
No, my lords.
would
I am very
make a
clear.
submission with
I am very
responsibility.
clear, my lord.
So we are not concerned with A scheduled
A schedule.
properties.
Only in so far as B schedule.
So we are only concerned with B scheduled properties.
Yes, my lord.
So we are saying, are we right now, just kindly hear us?
Yes.
Status quo with regard to
B schedule.
title, possession and nature of B scheduled properties.
Yes, my lords.
That's right?
Yes, my lords.
Till the next. Ma'am, just cut A. We are cutting A, only B,
Yes, my lord. Only B.
only. Now you are in possession of all these properties.
Only B schedule property, entire I am in possession.
The learner counsel for the appellants state that the appellants are in possession of B scheduled properties. B scheduled properties. Full stop. In noting the submission made, comma, the parties shall maintain status quo with regard to the title, possession and nature of B scheduled properties at pages 108 and 110 of the paper book. Okay?
Yes.
Thank you.
Thank you.
Next.
Serial number 4, Shayajit Shetty. 4.
Appear for the appellants, my lords. We are filing a memo for withdrawal.
Ma'am, you appear for the respondents?
For 48 to 53, I'm on caveat.
Pardon?
I'm appearing for respondent number 48 to 53, I'm on caveat.
See, now what is this without prejudice? Have you seen the memo?
My lord, I have not been served with the appeal type.
Or you want a simpliciter withdrawal or what?
Withdrawal, ma'am.
Just give her a copy of the memo.
Yes, sir.
Ma'am, you appear for 48.
48 to 53.
Has notice been issued in this? You were served?
No, my lord, I have not been served.
No, otherwise notice on this appeal.
No, my lord. I'm on caveat, but I have not
Oh,
been
you
served.
are in caveat. Just say that though the counsel for the appellants has filed a memo for withdrawal, though it reads as under. We are simply allowing you to withdraw.
Yes,
The learner counsel for the appellant states, the appellants be allowed to withdraw the appeal. Full stop. Just say that we mark the appearance on behalf of respondent number 48 to 53.
Please,
The caveator.
please.
Full stop. Dismissed as withdrawn. Suffice to state, notice on respondent number 1 to 47 is still incomplete. Otherwise, you are the contesting party.
Please, my lord.
Huh? Now, what about the cost?
I think
To comply with the cost. We will not, we will just keep this application pending. We will have it next week. Okay, just say this, cut that. Though a memo for withdrawal has been filed by the counsel for the appellants, we find that an amount of rupees 10,000 has been 10,000 and 5,000 has been imposed to be deposited with the Advocates Association, Bengaluru. Full stop. The appropriate shall be that the cost be deposited before the next date of hearing. Okay. Re-notify this application now.
24-2.
Thank you.
Serial number 5.
And for the appellant, my lord, I pray for 1 week time to take steps in respect of the unserved respondent.
Let fresh notice be issued to respondent number 2. Returnable on
9-6. Serial number 6, the Dinesh Bhatt. Serial number 6.
I'm the
Yes.
appellant, Your Lordship. I was directed to take out paper publication with respect to respondent number 1. However, I've done the needful and I filed a memo to that effect.
Yes, so service affected, no?
Please,
We'll hear it, ma'am. We'll just pass over.
Lordship, I may request another day. Senior is not available today. A date may be fixed. We'll.
I mean, this is a date given matter only.
However, we're not ready today, Your Lordship. I pray for another day.
Just leave it. Just say that in terms of the order passed on 6/1/25, comma, a memo has been filed by the counsel for the appellant. Placing on record the paper cutting of the newspaper. Which is this newspaper? Vijay depicting the issuance of notice to respondent number 1. So we find there is no appearance for the respondent number 1 despite publication. We'll stop publication of notice. The notice on respondent number 1 is deemed to have been effected. Full stop at the request of counsel for the appellant. Raise this appeal for hearing on. Ma'am.
This is Salima Shukur, proprietor of Measures Isra Arts. Sir, 15-4.
Obliged.
Serial number 7. 7.
Appeared for appellant, my lord.
Take it.
Serial number 7. Appear for appellant, my lord. My senior is out of operation. 2 weeks time, my lord.
You have not served respondent 10.
Yes. Senior is out of operation.
He noticed this service, the service report on notice to respondent number 10 states left on the counsel for the appellant furnishing a fresh address of respondent number 10. Fresh notice shall be issued, returnable on.
11-6. Serial number 8. Serial number 8.
Petitioner, my lord. And the needful. Needful has been done, my lord.
Just say this, notice to respondent number 4 be issued.
Yes.
4, no? Returnable on.
11-6. Serial number 9. Praveen Kumar. 9.
Take for a week's time, my lord. I will do the
Let
needful.
notice be issued to respondent number 2, returnable on.
11-6.
Great.
Serial number 10. This serial number 10.
My lords, I've given NOC in this matter, my lords.
For the appellants in this case, my lord, I have filed a invoice wakalat. I have filed a invoice wakalat, my lord.
What have you filed?
I have filed an IA, my lord, under section, one second. Rather 924, your honor, to seeking the restore the case, my lord.
This will restore.
May I make one submission?
Yes, ma'am.
It's though I've given NOC, I have appeared on the last occasions and all. Now it's a suit for eviction. It was my lords, dismissed and possession was given back to the defendant owner, my lords. They came in RFA RFA, when the coordinate bench insisted on settlement, they stopped appearing. It was dismissed for non-prosecution. Then they filed after 7 months IA for recalling. That was also dismissed. This is the second recalling application they are seeking, my lords.
When was the first time dismissed?
My lords, in February 2023.
No, there was in July also it was dismissed.
23 to 2023, my lords.
23?
23 to
Ah,
2023. The first recalling was dismissed, my lords.
okay. Then do we have that order? 23 to 2023. 7, 9. Ah.
My lord, one request, my lord. My senior is in another court or engaged in another case. You may kindly pass over the case, my lord.
Just pass over. See that appeal, there are two connected appeals.
Yes, my lords. It's in respect of two properties, my
First,
lord, shop premises.
Restoration in only in one,
Yes, my lord.
which we have dismissed
Yes,
for
ma'am.
My
non-prosecution.
lords, both were tagged together. They were connected.
Right. So it appears that in the other, they have not filed it.
Uh,
So now in this other, let's see that, we'll pass over.
Could I appear, my lords? I should be present, my lords.
Yeah, obviously. Next.
11 adjourned. Serial number 12, Shri Sachin BS.
Hearing for respondent.
I appear for the appellant, my lords. But as per my instruction, my lords, the decretal amount of 60%, my lords, as ordered by this court, we have not paid, my lords, because we are not in a situation to pay, my lords. It may be heard on merits, my lord, because
Very well, we say nothing.
please.
Just say this, you appear for the respondent.
Respondent.
Just say that the counsel for the appellant fairly concede that the appellant is not in a position to deposit the 60% of the decretal amount as was directed by this court.
Please.
As was directed by this court, with a order dated 7/11/2023. Full stop, he requests that the matter be heard on merits. The appeal be heard on merits. List the appeal for hearing on. Paper books be filed within 4 weeks. Just say admit, paper books be filed within 6 weeks. List the appeal for hearing on. Give it in June.
My lords,
June.
There one submission, my lords. The respondent has died on, my lords, 3/2/24, my lords. By the time they may take steps to bring the LRs on record, my lords.
Full stop. Additionally, just say that just then don't say admit everything. Then say that this statement, 60% statement that he is unable to deposit 60%, that will remain. Let's cut it. At this stage, learner counsel for the learner counsel appearing for Dr. Zamir Ahmed states that he has since expired
3/2/24.
on 3/2/24. The learner counsel for the appellant, just give the details of
Yes, ma'am.
LRs. Learner counsel for the appellant states that he shall file appropriate application bringing the LRs on record. Adjourn to
3/6.
Please, my lord.
Serial number 13, Shri Gopal.
In this case, my lord, I am
Right,
from the
very
appellate. My lord, here, as per the direction, my lord, copy was served to all the respondents who are represented before the another single judge, my lord. Moreover, my lord, I have filed a memo before this registry, my lord, on February 2nd, my lord. A copy was served and they are represented, my lord.
Petition.
And also they have filed IA for vacating the stay
he is
granted.
appearing for R5
Blood
to R8,
R5 to 9, one group blood we represent, and 10
14
to
and
13,
17.
R2, R5 to R13 only contesting respondents. But both the groups, my lord, have filed application IA 2 of 2024 for vacating the interim order.
That's
And
by
IA
R9,
R5 to 9.
R5 to 9.
R5 to 9.
5-9, my lord, he represents, but cause this.
No, but yes. Now, do you represent R5 to 8 also?
Please, my.
Okay, we'll record that.
R2
Who represent 14 to 17?
But even in the writ
See,
proceedings,
notice to 4 to 17 is still incomplete.
My lord,
even in
the
the-
copy was served who is represented before the learned single
But
judge.
appropriate is the notice must go to the
There
parties.
there was a direction by this court, my lord, survey copy to that.
But you will, suppose he may not have any instructions, the council. Just say that
Right.
so and so who appears for respondent number 9 state that he shall appear for respondent number 5 to 8 as well.
Please.
The submission is taken on record. Hence, notice to 5 to 8 is dispensed with.
Please.
We also find that respondent 14 to 17 are still unserved. Though the counsel for the appellant states that he has served a copy of the appeal on the advocate who appeared for the said respondents. That's right.
Yes, yes, ma'am.
So we see there is no appearance for respondent 14 to 17. Appropriate shall be a fresh notice is issued to respondents 14 to 17. Returnable law. Now tell us,
Tell- my
you
lord,
want
IA
stay,
2,
vacation of stay.
Please, my lord. My lord, while issuing notice, my lord, on 12/2024, Honorable Court, my lord, pleased to say, parties are directed
My
to
lord,
maintain
kindly have it on
status quo.
24th, my lord.
Status quo with regard to award of compensation until further orders. But the proceedings, my lord, but the meanwhile, certain portion of flats, my lord, have been acquired for national highways. Because of this dispute, who is the genuine claimant, my lords, the national highways, my lord, have deposited the amount before the district court. And, my lord, the appellant's counsel, my lord, files this order before the district court. Then, my lord, all the proceedings before the district court, my lord, have come to standstill. But along with IA number 3 of 2024, my lord, I have produced the order sheet of the district court. Kindly go to page 25, my lord, along with IA 3 of 2000. The present proceedings, nothing to do with the, there, my lord, they have to establish they are the legal representatives of the original grantee so as to claim the compensation,
Right, but the issue, what has been stayed is the grant of compensation.
not the grant. My lord.
Release
Award
of
has already
compensation.
passed. Only the disbursement of the award amount. But that proceedings can go on. Kindly see the 25 page along with IA 3, my lords. Respond number, Umesh Babu, advocate so and so. My lord, page 35, your lordship. Along with IA 3.
Yes.
Learned counsel for respond number 2 to 12 files memo with copy of order. Honorable High Court of Karnataka, Bangalore in writ appeal 924 of 2020, wherein an order to maintain status quo with regard to award of compensation until further orders is passed. Compensation is awarded because of the dispute that is filed before the district. court.
Right.
But the application, my lord, filed by National Highways, only this, my lord. Kindly take, my lord, page 18, my lord, page my lord, 9, my lord, annexure R1. This is an application, my lord, filed by National Highways under section 3H4.
Yes.
My lord, to deposit the amount so that, my lord, this is a prayer. My lord, kindly
Have they
take-
deposited it?
Please.
Have they deposited before the court?
They have deposited the before this is, my lord, page 14, your lord, their prayer, my lord. Pass an order determining the person who is entitled to the compensation, which of the respondent is entitled to receive the
That's right.
compensation amount. All of us are, my lord, are parties before the district court. Let their proceedings go on, my lord. Otherwise,
No, but how will we, see, the rights have to be determined, na?
Yes, ma'am.
What was the issue before the learned single judge?
but for the learned single judge, my lord, the learned single judge, my lord, the appellants, my lord, for the writ petitioners who had challenged the order of the deputy commissioner, who has, my lord, set aside the order of the assistant commissioner, declaring that they are not the legal representatives of the original grantee so as to claim the grant.
And who are you, the subsequent purchaser?
So purchaser.
So now the issue need to be decided. They are claiming their right maybe through the original grantee.
Yes, ma'am.
Leonard Single just has recorded a finding. They have nothing to do with the grantee.
We will look into it.
Very well, very well.
But in any case, see, unless you may be right or he may be right, we need to determine it, then only the compensation will follow.
The Lordship is right, perfectly right. What I am requesting is, let the proceedings before the, this.
Let's maintain, let's serve, you serve 14, now 5 to 8, he's accepted it. 14 to 17 be served, we will decide the whole thing.
5 to 9 minutes, 14 to 17, they are not the contesting respondent. They have sold the land, they are, even in the writ proceedings, they did not.
See, we don't want, you may be right, ultimately they may not be interested because they have sold the land and gone.
That is the reason, my lord.
But we can't leave it by chance, suppose they contest, that notice was not issued to them.
Very well, very well.
Then there would be an issue.
Let that be, my lord. That's the reason
Let's say
we
that-
also sought for early hearing.
We will look into it.
Fix a date, my lord. Very short issue is involved.
We just say this, let notice be issued to 14 to 17. Will you serve hand summons also?
Yes, ma'am.
Including hand summons for service on 14 to 17, returnable on. Just say that Mr. Devdas, a senior advocate, appears for respondent number 9. Now, not 5 to 8.
No, no.
You will file wakalatnama for 5 to 8.
5 to 8, my lord.
Yes,
But
filed.
Respondent number 5 is no more. During the pendency of this appeal, she passed away. And respondent number 6 also is no more. And represented by they are the respondent number 7 and 8 are the legal
There are many gaps to be filled.
Please.
Do one thing. He says that he shall also appear for 7 and 8. They are alive?
Please.
10 to
Full
13.
stop.
She
He
represents.
also states that according to his information, respondent 5 and 6 have expired. He shall take instructions and file appropriate application on behalf of respondent number, on behalf of the legal heirs of respondent number 5 and 6. That's right. He shall file wakalat on behalf of respondent number 7 and 8.
10 to 13 she represents. Who has
10
filed?
to 13, ma'am, just take the
Ansuya.
appearance, ma'am. Her appearance.
They have filed an application for vacating.
Next.
Date
3/4,
3/4.
3/4 April.
When was the amount deposited by NHAI?
my lord, on the date of the, my lord, that is IA3 itself.
2020, madam.
2000?
24th August 2020. When they made the application.
But
page 9,
has it been kept in the FD?
They have said,
The part of the land was acquired for a national highway. That amount was deposited because of the dispute, my lord, that amount is deposited.
No, we want to know, has that amount been kept in FD?
no. Normally, my lord, it's not done because district court did not expect that their proceedings would be intervened because of the status quo order. ಇಲ್ಲ district court. For 7 of their
Where is the order of deposit?
But we have not produced. But but at page 29, your lordship will get order sheet below dated 15/11/2020. 22. Payment of rupees 97 lakhs 3,890 had made to the manager SBI BD Rural Branch Chitradurga towards FD amount as per order dated 24/1.
It's there. If you see page 30, the next page,
Please.
an amount of 97,389 kept FD in the name of districts and session judge.
Yes, sir.
So we wanted to know that it has been kept or not.
Yep. Please. 3-4.
Serial number 14.
Appear from respondent.
Appear for the appellant, my lord. This matter was heard last time, my lord, and your lordship has directed the bank to produce a charge sheet to find out whether that in the charge sheet it is specifically mentioned whether financial loss has been caused to the bank.
Where is that?
I produced, my lord. It's there.
We'll just see.
Short date, my lord. Senior will come in corner.
Just give us the charge sheet.
More along with that.
Memo,
More along with that.
memo.
31.
Oh,
Here, it is there. Which page is this?
this charge sheet, my lord. The first, second, third page, my lord. That is regarding, he has granted loan on fabricated documents. The cost, last cost is 480.27 lakhs. Like that, there are 5 charge sheets, my lord. In all the charge sheets, loss has been caused. Ultimately, total loss cost to the bank is 9.22 crores. And he was dismissed from the service of the bank. Ultimately, he preferred the review petition and all. He was compulsorily retired. Then the bank has forfeited the gratuity as per the procedure by issuing a notice. Against forfeiture of gratuity, this writ petition is filed. But now this honorable learned single judge, my lord, your lords may kindly see this order, my lord. Page number.
But LS, you don't dispute there is a loss cost.
There is no dispute. 922. 9 crore 22 lakhs.
Post cost.
Cost.
This is under the Payment of Gratuity Act.
Yes, my lord.
Ah,
There is a provision for forfeiture of gratuity.
that's right.
6 lakhs has been, he was eligible for 6 lakhs sum and all. Entire amount has been forfeited by the bank.
Then what is your submission now?
I do not know what is the that no earlier that learned single judge, my lord, that is what submission. The reasons for filing
You are for the bank.
appeal is
You are for the bank.
I am for the bank.
Yes. We just pass over, call the senior. We'll hear the
My lord,
matter.
only 1 second, my lord. This honorable learned single judge said because he has caused to the loss to the bank, bank has filed the complaint before the CBI. Unless he is convicted, bank cannot forfeit.
So
the
we have
gratuity.
seen that.
That is,
See, he is going on a part of that section This section also says even where there is a loss, there can be a forfeiture of gratuity.
Yes. And the second section also proved, my lord, because court has convicted him now for bribe.
Pardon?
Court, this honorable, trial court has convicted him on 7th February, just recently.
Oh, he has been convicted.
Convicted also. So therefore.
For the same subject matter?
Same subject matter, he has been convicted, my lord, that.
Then call the senior, pass over. See this. Intervene subsection, the right to payment may be partially forfeited if the service of people has been bypassed. Disseminate the service has been terminated for any reason which constitutes moral turpitude, provided offense in the event of further also where there is a loss is caused to the employer. But losses. You can see has been convicted now. Yes.
15, Srimati Maitreyi Krishnan.
15, I appear for the respondent. I made a request.
No, we will hear this matter. What is
We
this?
have
We
not
don't
been able to
understand.
file a synopsis and list of authorities.
We'll hear her. Ma'am, we'll pass over, we'll come back.
May I, my lords?
Could you
We'll
lordship
just pass over the matter.
To us, could you lordship accommodate? my
Let's
lordship?
hear, just wait. Pass over.
Very well.
16, Sri Vasant.
This also will come.
16,
Pass over.
17, Sri Ramesh.
Except for the appellate, my lord. The
Who is for the respondent?
wanted BBMP, my lord. BBMP. It had issued a notice, A1 to A3, saying that I am running a hotel by obtaining a license. It is in a residential zone and only 20% is permitted. And also, it had another grievance that I had not obtained fire license. That was challenged. High Court said, the single judge said it is not 20%, it is 30%. That's why I have to vacate. I have to surrender. Your Lordship may kindly see in the similar matter, it was tagged on with the another writ petition, wherein the fire license was cancelled. Was held to be not necessary. Fire license is not necessary.
Where are the other side? Where is the other side?
The court said first time issue notice and we'll seek stay of the subsequently, but I am seeking stay of the pattern. This is another matter.
No, we will let the other side come. They have been issued notice now. Notice.
Yes.
Just say pass over. Let's see. Pass over.
18, Bhargav.
Appeal may be dismissed as not pressed, my lords.
You want to withdraw this?
I want to not pressed, my lords.
Although there is an issue of maintainability.
My lords, we have filed another writ petition, my lords. So that is the reason we are not pressing this matter.
So shall we record that you have filed a writ petition, you want to withdraw this?
It may be as not pressed, that's it.
Tilana counsel for the appellant states that the appeal be dismissed as not pressed. Ordered accordingly.
Much
Next.
obliged.
I took an objection on the maintainability.
My lord's permission. My lord, this appeal arises out of an ex parte order that the court passes using its section 9 jurisdiction under the Arbitration Act. Before I point out to the impugned order, my lords will see that an order has been passed under the arbitration jurisdiction on parties who are not parties to the agreement at all. The dispute that the
9, you are in 9.
I'm in 9. I'm not a signatory to the arbitration agreement.
Will that be a requirement?
My lords will,
9.
now my lords will see what the dispute is about. Broadly, my lord, the appellants before my lord are 3 employees of the respondent, pro forma respondent number 2. The respondent number 1, who is the applicant before the court under section 9, makes an application saying, I have been found out to be misappropriating confidential information of my company. I have in the process during giving my resignation have to admit to all the information I've taken. The information taken amounts to close to 10,000 pages of material, including sensitive material that belong to banks and other NBFCs. And therefore, now when headhunters are reaching out saying that let's do a background check, and my company and through these officers are
You have
forced to
been
say,
restrained.
yes, he files a Section 9 application saying restrain these appellants from making any defamatory statements
What have you
against me.
done against that material?
I have filed, I have submitted to the police. The police has investigated him. They have even prepared a charge sheet. And he's using this to circumvent those proceedings. And he's using this to ensure that I do not make any disclosures to headhunters or any other authority.
No, arbitration clause is between whom? Between
Between the
employer,
company and him.
the employee.
Yes, my lord. And the
Company is a party. No?
company's respondent number, I have made the company also party a pro forma respondent.
Right. But
Yes.
will that be, see, when the relationship is this employer-employee, his grievance is qua the employer.
That's right.
That's right. May not be against the officers.
That is right.
But to that extent, 9 is maintainable.
What I will submit, my lord.
And even otherwise.
Yes.
You can't restrict 9 only to the parties to the arbitration.
What I will instead submit, my lord will see the impugned order and the reasons given, because it is passed at an ex parte stage without consideration of any circumstances. And most importantly, my lord, the incident that the applicant complains of happens in June of 24. He approaches the court for the first time in October of 2024. And on day 1, an ex parte order is granted.
Are the
without
proceedings
notice.
still pending? 9?
They're still pending, my lord, and in ex parte order.
Work it out there.
I have submitted my objections. I've been pressing for an arguments date on date, and it is extended.
Now, what is the
And-
date now?
And today, my lord, another important aspect that falls is that 1st of October 2024, the order is granted. The rules as framed by this honorable court say that within 90 days, unless there is a manifest intent to commence arbitration, the order should stand vacated. 90 days are long gone in December. We are 2 months in, 1.5 months in.
He has invoked arbitration.
Only against the company, nothing against me.
Obviously, it has to be that way.
And my lords may see the order, my lord. Please have page number 79.
Tell us one thing, will it not be appropriate for you to go back and press your 9 or
I have, my
objections?
lord. I have, in
Do
fact,
that.
before filing the
Date
appeal,
of hearing now.
what I've, in fact, for 3 months before I approached my lords, I have been pressing the matter before the trial court. Only since it is now not being heard and instead this order is being misused, that I'm forced to come before my lords.
Here,
And my
R1 has been served.
lord, it's coming up for the first time. What I would request, my lord, may just have the impugned order, which is at page number 79.
You can't have parallel proceedings. You know,
My lord, may
one
just
there,
have
one
the
here.
have the order for a minute, and I will point out the judgments that this honorable court has passed in
You
orders
may-
of this nature.
You're right, but you will still go back there. The
I-
proceedings are pending there.
I maintain that, my lord. I'm not asking for the proceedings to be interfered with. All I'm requesting, my lords, will see the impugned order at page number 79.
He has restrained you.
Yes, saying you shall not make any statement
Obviously, he has restrained you.
without any reason, my lord. Now, my lords may compare this with what my lords have said.
It is simple.
Yes, my lord.
It may possibly not inure to his benefit. He is not going to gain anything. We'll tell you why.
Right, my lord.
He suppose applies for a new, with a new employer.
Please, my lord.
He will give you the details of his previous employment.
Please, my lord.
He will give the name of the company here. They'll get back to you.
My lord, that is obviously on.
1 minute, they'll
Yes.
get back to you.
Yes, my lord.
They say, we want information about this gentleman. That is what has been restrained.
My lord, what the court says, please see, my lord, please see the operative portion.
Hmm.
I will read from page number 79, which has the impugned order.
Hmm.
So and so find the applicant stated that the respondent number 1 is the employer, respondent number 2 to 4 are engaged in the management of the respondent number 1 company, and he has resigned from the company by sending an email on 2/6/24. Later, the respondent snatched mobile phone, laptop belonging to the applicant and his personal use and changed the password. The apprehension of the applicant is that the respondents may publish the post on social media defaming the applicant. On going through the pleadings, document number serial number 1 to 12 filed in the suit, I find that there is a prima facie case, balance of convenience lies in favor of the applicant. If the injunction order is not granted as sought by the applicant, the purpose of filing the suit will be defeated. Hence, notice under 39 Rule 3 is dispensed with. There is no consideration of the attendant circumstances. And what it is practically turned into, my lord, is an unending order against me, which is being misused today. It is one thing to say that you shall not defame, and I have no intention of defaming. In fact, not one instance has been pointed out as to what I have said. The issue is the misuse of the order. And what my lords have said in several judgments is that there must be consideration of the Morgan Stanley points. which says that has the applicant come on time? Is notice going to defeat some purpose? Today we are, my lord, 6 months from the date of the so-called incident by the applicant himself, 5 months from the date of the filing of the Section 9 application. An ex parte order has been passed. I have not sought a single date before the trial court. I filed my objections promptly, in fact, advanced the matter, but the order continues to stand. And lastly,
What is the date there?
19th, my lord, I have advanced it. The court adjourns it each time.
We will say so. Tell the court. We will tell the court, they will hear the matter and decide it. That's right.
Please,
We will say so.
would my lords also consider my IA that only let the proceedings carry on, let the order not continue, my lord.
We will not say anything, let the court decide. See, then once 9 is decided, you have a remedy.
I do, my lord.
That's right.
Yes.
You come back. If at all there is an order against you.
My lord, because what I'm also staring at today is sub rule 4 of rule 9, which is that by operation of law, this order ought to have come to an end.
Right. Then you take that stand.
I have, my lord.
1 minute.
Please.
Then your appeal also goes.
My lord, one way, because today what I'm faced with is that the order has been extended. Either my lords may indicate that in view of rule 9, the trial court will anyway.
You will argue everything before the trial court.
Please, my lord. My lords may then.
Possibly argue this also in view of 9(4). This cannot be even extended.
Please, my lord.
Or this by the operation of law, it has come to an end. You can argue that.
In fact, my lord, on 5th of January, and a memo has been filed stating as much. Till date, no orders have been passed, my lord, and that is why I am forced to appeal.
We will say so. With 19th, it is everyone is appearing there.
Yes, my lord.
So then we will say, just say this. The challenge in this appeal is primarily to an order dated 1/10/2024, passed by the principal just say the additional cities.
Civil and Sessions.
Cities, City Civil Court and Sessions Judge Bengaluru, whereby the court has granted an interim order in favor of the respondent number 1 herein. Full stop. The grievance of the appellant as contended by their counsel is that despite the appellants filing their reply to the Section 9 petition, the same has not been heard. He also informs us that the date of hearing before the court below is 19th of February, 2025. If that be so, we deem it appropriate to dispose of the appeal by directing the City Civil Court Sessions Judge Bengaluru to hear the parties, to hear all the parties in the what is the petition number?
A48, my lord. 48 of 2024.
No. What is the petition number? How does it call?
Arbitration application number 48 of 2024.
Arbitration application number 48 of 2024. On 19th of February 2025, or to a date immediately adjourned thereof, and decide the same within 10 days, 10 days of reserving the case for judgment. Okay. Full stop. Thank you.
Deeply obliged.
Yes, thank you.
20 to 22 adjourn. Serial number 23, Shri Rakshit R.
23.
Pass over me.
My lord, 23.
23, sir.
Yes.
Yes. You appear for whom?
Dinakaran, my lord.
Huh?
Dinakaran.
Acha, you appear for Mr. Dinakaran.
Yes.
Yes, what do you say?
Yes, my lord, Dinakaran has done a lot of work in railways, but Honorable sole arbitrator has given only 10 lakhs. Actually, he himself has committed in the last page number 36 of his report, that about 30 lakhs of work has been done by the Dinakaran. And
No, you appear, you are the counsel. What is your name? Good name.
mine was Radhakrishnan Jayakumar. This is the filing. Sir. Rashid is not, he has not turned up actually. So we are filing the interlocutory thing.
What are you filing?
I'm going to appear for him.
Is it a wakalat?
Yes, I've already given the first wakalat, but
Seconds.
yes, already my name is there in the first. And Rashid, first is Radhakrishnan Jayakumar already given. Both of us, first my name came, Radhakrishnan Jayakumar. Now I'm filing it second time I'm doing it. Along with the Pavitra. My name.
Four, 6.
Thanks.
Serial number 24. 24, yeah.
Appearing on behalf of the appellant, my lords, senior is held up in another.
See, it's a small correction in respect of the order passed by this. No, they have filed the application. In fact, they have moved the
My lords, the matter.
benefit lies in their procrastination.
The matter may kindly be passed over, my lord. Senior is held up in another.
Please. Respondent. Certainly I do.
Yes, ma'am.
$25.
Appear for respondent, but I am filing additional statement.
Last occasion, a matter had come up.
Oh.
I had filed application, my lord, seeking, bringing it to your lordship's notice during the pendency of this appeal. They have been removing the soil, your lordship. Kindly see the photograph for a moment, your lordship. This court, they are removing this entire soil, my lord, which is the subject matter of the suit, my lord. Yes, Your Lordship. Last occasion, Your Lordship, see the photograph, Your Lordship. Afterwards, my Lord, time was fixed to file the objection. Today, they served the copy, my Lord.
I am producing the photograph. It is.
What they say is that para 1 may not may kindly see. That's all that they say. They are doing nursery business, therefore we are doing this. That's the a barren land, my Lord, which was kept intact, which was the agreement, subject matter of the agreement of sale and the pendency of the suit, my Lord. The first para, Your Lordship may kindly see. There is no nursery, anything. They are now started to do that under the guise of removing the soil and photographs which I have produced. My Lord, injunction order I have sought, Your Lordship.
Not, I have not.
The suit for specific performance was filed. No, there is no stay, Your Lordship. It is, I am before this honorable court. I am seeking for grant of interim order because of the reason.
Let's see the judgment decree.
Yes, Your Lordship. What is granted was, my Lord, to stay of alienation, but not the injunction order, my Lord. Therefore, we are before this honorable court.
You were the defendant?
I was the defendant.
They were the defendant. We
Suit for
filed a suit
specific
for
was
specific
dismissed.
performance of the agreement of sale, Your Lordship. They have received substantial amount, my Lord, towards the sale consideration. Then they did not come forward to execute the sale deed. We were constrained to file a suit for specific performance. There we sought for injunction order, my Lord, not to alienate the property, my Lord, which has been granted.
But why did you file the appeal?
My Lord,
What
because,
is-
my Lord, the injunction order was refused, Your Lordship. That is the reason, Your Lordship, we filed.
No, if you see
Yes.
page 71,
21, my Lord.
as a suit dismissed with cost. You sought specific performance.
Specific performance, Your Lordship.
And what is there any interim order here in this court?
Not to alienate, there is.
Not to alienate the property is there in this, before this honorable court. In the meantime, they are removing the soil, my Lord, which is the subject matter of the.
But what difference it would make if they remove the soil also? They will not alienate.
That's why, my Lord, once the land has, once the nature of the land has been changed, Your Lordship, I may not be able to utilize or something.
In what manner they will change the nature of the land?
My Lord, you kindly see the photograph for a moment, Your
Very
Lordship.
right. They are putting saplings. They are putting small plants there.
No, nearly about 6 feet soil, my Lord, has been removed to making it cultivable by them. The soil, my Lord, it is very difficult to get the soil, my Lord, today. If the soil, fertile soil has been removed, in the event if I succeed in the suit, my Lord, I can't come back and bring back the original land, my Lord, to the original position. It is very difficult to fill the land through the soil, my Lord. Yes.
I am not changing the nature of law. I am not removing soil also. We are doing the nursery. That is the pleadings also, even the
Yes.
yes, Allah, I will not remove and selling the, that's what I am the filed affidavit in that, to that effect. We are only for cultivation purpose, leveling the land and
12 acres
for
of
purpose of.
soil, 12 acres.
That is the reason. No, now Your Lordship, can you see there was a fixation of boundaries between the my and the adjacent owners. After fixation, it was opposite, therefore I level the land. And I have planted the coconut trees and the coconut trees.
Now, do you intend to or change the nature of?
No, no, it is only agriculture and I am not changing any nature of the business land, my lord. 10 acres, it is, you last may kindly see 10 acres of land. Your lordship may kindly see page number 10, I have read the photograph. No, this is, you last may kindly see the nature of land, page number 10, you last may.
Total 12 acres of land, your lordship, is the subject matter.
Page number 10, photograph, you lordship. Yeah, that is the last, this is
Page
the,
6.
this is the boundary fixed by law, that the upper portion does not, belongs to the neighbor. No, you lordship may kindly see, I am.
Photographs,
That is the reason, that is the.
photographs produced by me, my lord, may kindly see, my lord, on the last occasion.
Oh, that is
Which
the
is now
reason.
planted, your lord, which is now
Now, lordship
planted.
may kindly see the upper portion
Kindly
is
see the height of
the
the-
neighboring land. The upper portion is neighboring land.
The height
Now,
of the
the
soil.
boundary was fixed recently.
Height of the
This
soil.
portion I have planted coconut tree and coconut tree.
Height of the soil
I
itself would
I
be
have no reason
6 feet.
to sell the soil, my lord. Your lordship may kindly see the, I am not selling the, I have stated in my affidavit. Your lordship may kindly see page number 6. The agricultural land I am doing, my lord. You,
They are only saying till the next date of hearing. We will set out the appeal for hearing.
no, that is well, my lord. If it agricultural land is, I have to.
We don't understand in 1 month or 2 months what is going to happen. Will that make any difference?
If it is, if that is the case, and I cannot pull the water and all the plant will become dry, madam. All the plant other become.
We will do. We will not dig the land and remove the soil.
Your lordship may kindly say, remove the, you should not remove the soil. That's what I have stated in the affidavit itself. That's all. That's what I have stated in my affidavit. I will not remove soil. I have not removed soil. That is the reason. Remove soil, your lordship may kindly say, I am doing the nursery. For nursery plantation, it has to be stored in a plastic cover and your lordship may kindly, this is the.
My previous application, my lord may kindly see. Now it has been brought to, after the time was taken by them, they leveled the land every day.
Your
5 to
lordship may
6
kindly see page
JCBs
number
are
8.
working.
Page number 8, your lordship may. Page number 8 photograph. This is the nursery. This is the, for that purpose, the soil will be stored in a plastic cover and that will be plantation.
Not by digging 6 feet. Not by digging 6 feet.
6 feet because your lordship may kindly, that was
Their own photograph shows. Say this.
No, this is not, this is the recent, after fixation of the boundaries by the others, neighbor, this is put into cultivation now. Earlier cultivation, your lordship may can see all the other photographs, there is no digging. This page number 10, your lordship, that is the boundary fixed by the, between me and the neighbor. That was haphazard.
Just say this is an application, 1 of 25. Huh? This is an application which has been filed by the appellant with the following prayer. To stop in effect, the appellant is seeking a direction against the respondent, or his agents from changing the nature of the suit scheduled properties. Is it one property or properties?
12 acres, my lord.
Properties. How many properties are there?
Only one property.
There are two properties, your lordship, measuring 12 guntas, 12 acres, my lord.
12 acres.
Totally measuring 12 acres.
Properties as depicted in the application, including excavation and removal of soil.
Yes.
Till the disposal of the appeal. Full stop. In support of his submission, the learned counsel for the appellant has drawn our attention to photographs at pages 6, 7, 8. Full stop.
Yes.
He states that if in the eventuality the appellant succeeds in the appeal, comma, in the eventuality the appellant succeeds in the appeal, comma, it would be difficult for the appellant to restore the rand to its normal position.
Yes.
Full stop. On the other hand, the learned counsel for the appellant who has filed an additional statement of objections.
Respondent.
A respondent who has filed the additional statement of objections in the court, comma, the same having been taken on record, would contend that the respondent has no intention to remove the soil in order to sell it to the third parties. His submission is that the respondent, being an agriculturist, is carrying agriculture operation and also doing nursery business, which fact is undisputed by the appellant throughout. Full stop. He also drawn our attention to photographs filed by the respondent in his objections in support of his contention. Full stop. We have seen the photographs as filed by the appellant and also by the respondent. Full stop. We do find that the removal of soil, as the respondent had removed the soil from the surface of the land. Full stop. To plant certain trees. To plant certain trees. Full stop. At this stage, the counsel for the respondent states that as per his instructions, comma, no soil shall be removed henceforth by the respondent except watering the plants which have been planted, watering the saplings which have been planted. Okay.
You will do the agriculture operations.
We are only saying watering, nothing more. No removal of soil.
No, I will not remove the soil, my lord. Agriculture purpose.
No, we are only saying watering. That's all. Obviously, you water. Very well. Manuring also. Watering and manuring of the plants, oblique saplings. Full stop. If that be so, comma, we dispose of the application by directing that the respondent should not remove the soil from the scheduled properties. Excavate, oblique, remove the soil from the scheduled properties. Full stop. He's allowed to water and manure the plants which have already been planted. Manure, oblique, water the saplings which have already been planted till the next date of hearing.
Obliged. Insofar as other interim order may be continued. Not to alienate.
Stop. The interim order passed on 9/2/2022.
Date also.
Is this allowed?
Not to alienate this.
Full stop. That order is allowed, final.
Yes.
Full stop. The order dated 9/2/22 shall continue
Grateful.
till the next date of hearing.
Grateful. Any date is given, your lordship.
Yeah, we are giving you date.
Grateful, your lordship.
10/6.
See, this application has been allowed. That means the order will continue till appeal.
Yes.
So no need for us to continue. Don't say last one. Cut it.
26.
It says. In further also. Finally. That attains finality. Next, yes.
I pay for the respondent, please.
Yes.
Plaintiffs appeal, my lords, from a refusal of grant of interim order in a trademark infringement suit. Plaintiff was.
Sorry to interrupt my learned friend, but I appeal for the respondent. I filed IA-1 of 2025 for striking out the memorandum of appeal, my lord.
Striking off?
The memorandum of appeal.
Why?
For, my lord, violation of Order 11, Rule 6, my lord. Sorry, Order 6, Rule 15A, my lord. To make I have the interim application.
You filed it, this is under 13(1)(a). Let's see this.
It's a commercial appeal, my lords, under 13. The ex parte order had been granted in my favor in April 2023. 18th June 2024, it was rejected.
Tell us one thing, ma'am, just give us CPC. Is it appealable under 43, na?
Yes, my lords.
Please, it is.
Then how can that be?
Please, my lord, I'll just take my lordship through the application itself.
Show us. Huh? Yes.
My lord, page 4 of my affidavit, my lord, para 4. The application has been filed on the basis that there has been a deliberate and conscious, my lord, non-compliance with the provisions of Order 6, Rule 15A, which mandate, my lord, the filing of a statement of truth in a prescribed format, my lord, which is again prescribed in the Commercial Courts Act itself. Please have, my lord, page number 5. Para 6, my lord, I have culled out, my lord, the specific paragraphs from the prescribed format, which have been omitted by this appellant for reasons, my lord, best known to them. But these are, my lord, very significant paragraphs because they, my lord, verify the truth of the averments made in the pleadings, as well as, my lord, verify the documents, etc., etc. In this context, my lord, this application has come to be filed because the statement of truth does not comply with the format that is prescribed under the Commercial Courts Act. And therefore, my lord, under Order 6, Rule 15A, Sub-Rule 5.
It's as good as not filing a statement of
precise.
So far as the plaint is concerned, I have filed the statement of truth. It covers everything. There are no new pleadings before this honorable court in the appeal itself. I have filed a statement of truth along with my appeal at page 56.
With minus these paragraphs.
Because I have not produced any fresh documents. So this does not apply to me. In fact,
where is the plaint? Plaint is there.
Plaint has been produced, my lords, before this honorable court. The pleadings are all complete. There are no fresh pleadings of fact or documents
So what
produced
prevents you to say so for this appeal also?
Only 3 statements are missing, my lords, if I may just point out. The format says relevant for the present suit. That portion has been removed. No fresh documents have been produced here. All my documents that I have produced along with my plaint with a statement of truth saying so.
See, 4 would be relevant, paragraph 4. No false statement, concealment of any material fact. Now that statement of truth would hold good for an appeal provision also?
Well, in my submission, it does not, because this is not a pleading. The appeal memo is not a pleading under the definition which includes plaint and written statement. Under the CPC, definition is clear, only plaint and written statement. Formally, this is not actually required at all for an appeal. In fact, when we file an appeal, an RFA.
Order 6, Rule 15A.
Please.
Which has been amended.
It talks only of pleadings, my lords.
We can have it tomorrow. Let's examine it. We'll have it tomorrow.
Please.
Okay. Let's have it tomorrow.
Please, tomorrow.
Okay. Just re-notify tomorrow.
I just wanted to say there are some judgments which earlier rejected suits on this basis. There's a 10th February.
Judgments are there.
Please,
Even
Mr.
Supreme Court has said
Please.
everything. That's on a suit, you are right. We are
Please.
only on the appeal, what is the difference?
Please. In fact, I have filed my objection saying it's non-essential, but all of the judgments also say it's a curable defect. So if directed by this honorable court,
That part need to examine that.
Please,
one.
Mr.
But insofar the suits are concerned, those judgments are clear.
Absolutely, and I am in full
Correct.
compliance with those.
Just one
There's no,
peculiar.
this application, my humble submission, has been filed today after 6 months of delaying my appeal as another delaying tactic.
Not at all.
I've been trying
In
since
fact,
August.
My lord,
have-
let me kindly see my learned friend says order 6 doesn't
After
apply.
multiple, after
have already
multiple
filed an
hearings,
IA
it is
for
filed
amendment.
at this stage.
Will you reserve it for tomorrow?
Grateful.
We'll have it tomorrow.
Please.
Ma'am.
26 and 27 are both appeals from 2 IAs in the same suit.
Tomorrow.
Grateful.
28.
My lord, I represent the review petitioner in this matter.
Yes.
My lord, there is a delay of 165. My lord, it is noted as 165 days, but whereas the actual delay is 110 days. There needs to some correction. My
You
lord,
say
has
on the
to be-
review.
Yes, my lord, the review. I am a defendant in the suit, my lord. Suit is filed for recovery. The suit is filed in the year 1995, my lord. I entered appearance and did not file my written statement. I took the stand that in view of the arbitration clause, my lord, under the old act,
What is the error apparent?
my lord, my lord, may kindly turn to the judgment. My lord, the error apparent is this. My lord, I had raised on ground, my lord, in the RFA, that my lord, I am entitled to, my lord, exclusion of time limitation under section 14(2).
How much?
Because,
Which period?
my lord, throughout I've been agitating about the, my lord, the arbitration clause.
When did the
I
cause
did-
of
I did
action
not-
arose? One
Cause
minute,
of
please.
action,
1
cause
minute.
of action, my lord, arose. My lord, initially there was my lord, my stand was not upheld, my lord, my stand that the arbitration clause, in view of the arbitration clause, the suit is not maintainable, was not considered. And the suit came to be decreed. I had never subjected myself, my lord, before the trial court.
But you
Against
filed a
the decree,
suit. You filed a suit.
please, my
Raise the
lord.
question. You have filed a suit.
No, I am not, my lord, I am the defendant in the suit.
Yes.
I am the defendant in the suit. I took
There was an
this,
earlier suit filed by them also?
my lord, that is the only suit. There is no separate suit.
Yes.
My lord, there was an ex parte decree which was passed against me, which I
Yes.
sought for setting aside under Order 9, Rule 13.
Yes.
My lord, which was also rejected, my lord, in the year 2022, this honorable court, my lord, a learned single judge, allowed my MFA against, my lord, the Order 9, Rule 13 proceeding. And my lord permitted me to go back to the trial court and contest the suit on merits.
Yes.
My lord, for the first time, I filed my written statement along with the counterclaim. My lord, the other side takes my lord, the plaintiff takes an objection that the suit is barred, the counterclaim is barred by limitation. On that, my lord, the learned trial judge, my lord, rejects the counterclaim against which the RFA is filed.
Now, your case is you were pursuing some litigation elsewhere or some
Yes, my lord.
proceedings.
Yes,
for
my
which
lord.
you are entitled to the benefit of section 14.
Please, my lord. There
What
were
were those
proceedings in
proceedings?
Lucknow. There were proceedings, my lord, before the Lucknow Civil Court for the appointment of an arbitrator under section 20 of the old act. Proceedings, my lord, were initiated in the year 1995 by me.
For an appointment of an arbitrator, did you file a section 8 or 11?
My lord, under the old act, 1940 act, my lord,
Okay.
section 20, my lord, it
Yes,
was numbered
yes.
as a suit before the Lucknow Civil Court.
When was that suit filed?
1995, my lord, numbered as RS 172 of 1995.
Yes. And when was this decided?
That was decided, my lord, on 14/3/2001, that came to be dismissed.
14/3?
2001.
2001.
Please, my lord.
Yes.
Now, as against that, an appeal is filed before the Honorable Allahabad High Court. An appeal is admitted, my lord, and the order of dismissal is stayed by the division bench of the Allahabad High Court on.
When was that?
My lord, that order was passed on, my lord, 6/8/2002.
And when was the appeal decided?
Appeal is still pending, my lord. Even to this day, that appeal is pending.
Then why did you file your counterclaim?
The counterclaim was filed because this honorable court felt in MFA that I have to subject myself to the jurisdiction of the civil court. That order was passed in the year 2022, my lord.
So then, see, earlier.
No, I'll just make one more submission, my lord.
Yes.
This RFA was dismissed, against which an SLP was filed. And my lord, at the stage of admission, the Honorable Supreme Court felt that this Honorable Court has to look into this aspect about whether I am entitled to under section 14(2).
Where is that order?
My lord, unfortunately, my lord, that is not part of the paper book. It's a brief order, my lord, passed in the SLP.
Where do you refer to in your review?
I have referred to that, my lord, in paragraph 16, my lord. 16 of the review petition.
We want to see the order.
My lord, may I, if it is listed tomorrow, my lord, I will produce the order. May I, any shorter day.
Have it tomorrow, please. We want to see this order.
Yes, my
Can
lord.
you read that order, please?
Yes, my lord. After hearing the learned counsel appearing for the petitioners, states that the petitioners would file an application for review as the impugned judgment does not take notice of the relevant provisions of the Arbitration Act 1940 and the Limitation Act 1963, which provide for exclusion of time for the purpose of limitation, as well as the facts of the present case.
Just 1 minute. In your RFA, where is the RFA? Have you filed the RFA?
Yes, my lord.
The appeal paper book?
I have just furnished the order copy, my lord, the order passed. Yes, my lord, I filed the RFA also. That is, your lordship will get it at page 91. Page 91.
Where is the ground you have taken?
My lord, I have raised that ground in paragraph 12.
Page 95.
13, paragraph 13, my lord. Page 95.
Yes.
The learned trial judge failed to appreciate that prior to passing of the decree on so and so, the appellants were continuously agitating their contention that the suit was not maintainable in view of the arbitration clause, which was ultimately negated with the order of remand passed in MFA so and so. Assuming that the appellants had made their counterclaim in the first round of litigation before the trial court, it would have virtually meant that the appellants had submitted to the jurisdiction of the civil court. Hence, these aspects required to be examined by the trial court by holding a trial in the matter. This was the ground I had raised.
We will have it tomorrow. Please get that order.
Yes, my lord, I will.
Mission. Notes in writ appeal 497 of 24. It was argued by Senior Counsel Jaikumar Patil. Notes in the morning session, the appellant has filed return as submission. Notes I'm filing the additional list of citations notes on behalf of respondents. Respondents. Please. Notes. I have served the copy. Additional citations, list of citations. Judgments, citations. Yes.
Call that counsel. You do one thing,
Please.
call the counsel to appear for the appellant.
Please, Mr. Please, Mr. Call.
Okay. Yes, then only you give it in his presence. Call him.
Please.
With my lord's leave. My lord, serial number 17, my lord, I was not present in the morning. My lords can accommodate me till tomorrow, my lord, I'll make my matters passed over there from morning. I have intimated the other side also. I could not be present before the court.
Speaking in brief state, because they are precipitating to close down the hotel business we have set up. And they have issued a license also up to 28.
We have to hear.
Yes, sir.
There is already a finding.
Not to precipitate.
It's like this, hearing you on interim, hearing you finally is said. So we will hear you, we can set up for hearing. What is the difficulty?
Lord, difficulty, my lord, is that my matter is continuing for another matter. That is, my learned friend is also aware, he saw me there, I arguing the matter. That is the reason, my lord, I could not be present. Tomorrow, no problem for me. Absolutely no problem. Findings are there against him insofar as why he should not conduct the respondent is concerned. I will substantiate that. Fact that, my lord, when the matter got listed for admission, please. 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 Much. I'm sorry.
17. Serial number 29, Jay Narayan.
First respondent. Respondent has filed a list of documents and synopsis.
Yes.
Appellant has challenged the order of dismissal of IA order 34 class 3. And also section 5. Not present. Section 5 of the limitation. There is delay of 5 years, 6 months in filing this.
Just pass over. In this call.
Sir, 20. Serial number 30. 30, Shri Chandan.
In this case, respondent. Today only I find your body respondent. The Gita Potare. Yes, man. So it was yes for the respondent. So there is already a find the Bakala. Today only, just now. You find it? Yes. What do you want?
Same stage.
No. Next.
22-4. Serial number 31.
Yes.
Partition, my lord. Filed by my sister, my lord, in the trail court. Same is partly decreed, my lord. Question, my lord, is that the property in question, my lord, belongs to my mother. During her lifetime, my lord, they have gifted the property in my favor. Those documents, my lord, I have produced before the trail court as exhibit D1 to D4. One more property is left, my lord, acquired by my father. That is BDA property, my lord. That property, my lord, is also orally gifted in my favor, my lord. My lord, please kindly see, my sisters have not filed any document before the trail court, my lord, with regard to establish that they have not received any, my lord, share.
You are the brother.
I am the brother, my lord. All the document established, all the document is in my favor, my lord. Those documents I have produced before trail court. Exhibit D1 to D4. Yes. And apart from that, my lord, during their lifetime, during my parents' lifetime, they have received the, my lord, their respective share. After lapse of, my lord, 20 years, the death of my parents, the present petition is filed.
Was it your case that the properties have been partitioned or some equivalent to the properties have been given to the others? And or is it your case that it was gifted to you through oral?
Yes, yes, it is, the court is observed, my lord, page number 24, my lord. Para 17, my lord. Exhibit D1 to D3, my lord. Para 17 of the judgment, my lord. The trail court observed, my lord, with regard to the gift deed produced by me, my lord, before the trail court, my lord, as per exhibit D1 to D4.
Yes.
Apart from that, my lord, they are claiming share, my lord.
How many properties are there?
My lord, totally 3 properties, my lord.
Who is in possession?
I am in possession, my lord.
What is the stand of the other sisters?
Other sisters have not filed, my lord. 224 not filed, my lord, WS.
Did they appear before the trial court?
No, my lord, they have not appeared, my lord.
They were served.
They have served,
Who contested the petition? Who contested the suit?
only defendant, plaintiff, my lord. Only plaintiff.
And there is a decree, there is a judgment in her favor.
Partly declared, my lord.
On 7th in her favor.
Please, my lord.
Of all the properties.
Please, my lord.
There was a stay also, interim order.
No, my lord, so far not.
There was none, there was no.
Please, my lord.
When the others have been served.
So it's a KV.
Still notice to the other.
Execution petition, my lord, filed. FDP is filed, my lord, it is pending. There too.
Is the date of it?
But next week, my lord, next week is there. I do not know the date, my lord, but next week the date is there.
What is
The court, my lord, appointed commissioner. The court, my lord, appointed commissioner. Due to that.
Why are you coming so late?
My lord, this case was, my lord, allotted to the single bench, my lord. From there to here, my lord, takes time, my lord.
Where to get?
Here, my lord, in single lordship judge, my lord, single judge it is allotted first initially.
When was it allotted?
My lord, after due to the jurisdiction point of view, my lord, this one, the registry, my lord.
This is a 22 hour. Okay, that issue was somewhere in June 2024.
Yes, sir.
Right?
Yes.
So 22 to 24, no action. Remember the proceedings filed?
Proceedings.
Proceedings?
My lord, I have received the notice, my lord, about 2 months ago, my lord.
2 months ago.
Please.
And what is the date of hearing?
Date of hearing, my lord, next 26 or 27, my lord.
Tell us which is the exact date.
Exact date I do not know, my lord.
Please serve the other side.
Please, my lord. Till then, my lord.
No, nothing till then. Will you please serve them? This. Did they appear before the trial court? Respondents 2 to 5.
2 to 5 appeared, my lord, but they have not filed, my lord, WS, my lord. But they have received due to that cause only they have not appeared. They received their share, my lord.
Did they say anything in your favor?
No, not at all. Neither they are supporting plaintiff, my lord, nor they are supporting me in the court, my lord.
Dharma for R1.
Let's say this issue notice. To the respondents.
11/3.
7th March. Till then. Please serve them. Okay.
And also, my lord, who's standing, my lord, appearing.
These are only proceedings have started. You got the notice. There will be a commissioner appointed. Commissioner will go inspect. He will submit his report. The report will be placed. By the time we will hear this.
Eleven.
Thank you.
32, Shri Prakash Angadi.
My lords, I appear for appellant in this case. My lords.
Application seeking not the release of the amount. Not of the appellant authorities have not deposited not of the half of the amount while not obtaining the interim order. Not I have requested not these are not of the farmers. Their land has been not of the acquired not by the appellant here in the year 2011. Not of the 2013, even though award was passed, my lords, which has award amount is only raised in the year 2019. Lords, against which lords we have prepared and not of the petition before the deputy commissioner, lords who enhanced the not of the amount. Subsequently, they lords filed a lot of the appeal before the district judge. Judge also not the confirmed the order of the deputy commissioner. Against which, my lord, they have preferred, my lord, this MFA. Only on the ground that, my lord, there is a delay. Lord, I request not since Lord, half of the amount is still with them, Lord, only half of the amount they have deposited.
What do you say on that?
My lord, they have to furnish the surety, my lord, to ensure the.
If you receive that amount, whatever they have deposited.
No, my lord, still it is with the court. My lord, earlier amount was, this enhanced amount is not with the court, my lord, executing court.
Right. How much 50 of that has been deposited?
Yes, my lord.
But how much you have deposited?
Lord,
Lord,
I have furnished, my lord, that details. Lord, 94,61,466 was the, my lord, the amounts. They, half of the amount, my lord, 58,81,318. They have deposited in, my lord, MFA number 7835. Lord, I have stated in my application, Lord, may I take, my lord, to the application? IA number 1 of 2024, my lord.
See, his concern is
For 9.
whatever has to come must come to the court, no? Oh, she has given me. Yes, what,
Para number 9, my lord.
yes. 58 lakhs, 81,318 has been deposited.
Yes,
In first case.
Huh.
Second case also they have deposited.
in both the cases we have deposited.
Which is the second case?
Lord, see, second case is MFA number 7840 of 2022, my lord.
Hmm.
Item number.
That also, my lord, para number 9, my lord. I have-
Which is the order of deposit?
Lord, the order of deposit.
My lord, dishonorable court has passed an order stay subject to deposit of 50% enhanced amount, my lords, and as per the order of dishonorable
Do
court.
one thing, you will file the breakup of 50%.
Yes,
You will
yes, ma'am.
file
Yes, ma'am.
the breakup of 50%. How did you come to this conclusion that this is the 50%?
I will file, my lords, the total
How
enhanced
much is the
amount.
total compensation awarded?
Lord, the enhanced compensation is not the, in first case, my lord, so that is MFA number 7835, my lord. 7835, not enhanced compensation is not the 94 lakhs 61,000. Not as on not 31/12/2022. Not 9% interest was not levied. Not up to not 31/12/2022. We have calculated and filed the execution.
But you have seen this order?
Yes.
Order dated 26/2024.
36. My lordship, Justice Somsekhar.
Yes.
Order. Yeah, I have, my lord, sir. That also, my lord, I have mentioned it in my.
You're right, but what it says is having regard to the fact appellant has deposited this 5881,318 before the executing court and the reasons assigned in the application being found to be justifiably acceptable and the condition of deposit having been complied
Yes.
for stay are allowed as paid for.
Yes. Thereafter, my lord, I requested the, my lord, the trial court, my lord, by filing an application. My lord, where they stated that, my lord, when there is a stay by the High Court, my lord, we can't release that amount unless you get the order from the High Court. I have stated in that, my lord, in para number, my lord, para number 7, my lord.
But now para number 7 of the,
My lord, the application.
That's right.
Para number 8, my lord, sorry. Para
Ah.
number 8 of my application.
yes,
My lord, sir. The respondent number 1 approached the Honorable 5th Additional District Judge, Bangalore Rural District, Devanhalli, in execution number so and so, seeking release of the deposited award amount. The Honorable Executing Court rejected the payment application filed by the respondent number 1, stating that this Honorable Court in the above appeal stayed the award of the arbitrator, second respondent, and judgment of the district court. Hence, at this stage rejected the payment application, even though the respondent number 1 by placing the judgment and requested the executing court to release the amount. Even though I have not requested the trial court.
where is the order of the executing court?
Not the executing court.
So how will they release without a security?
Even the district court also has insisted for furnishing the surety, my
Request
lord,
is not-
security.
Only my request is not, these are not the farmers, not small extent of lands, not they are holding. Not the, in their family, not there is some, not the necessity for performing the marriage.
You're
and all.
right, you're right. We are with you on that. But no issue on releasing. But there must be some security, na? Suppose for a moment,
For that
the appeal is decided against you.
For that also, my lords, I have stated in para number 11, my lords, in my application.
Yes.
Lord, that respondent number 1 is entitled for the more than the deposited amount for the lands lost to the appellants. However, the respondent 1 undertakes, my lords, respondent number 1 is the applicant.
No executive, no indemnity bond. It has to be.
They are farmers, my lord. That much only we can do.
You're right. The only way is, although the issue is pending before Supreme Court, after how many years you went to the arbitrator?
My lords, 3 years.
More than 3 years.
3. My lord, the fact is that, my lords, even though, my lords, we had approached the, my lord, the arbitrator after 3 years, the fact is that, my lords, award is even though passed in the year 2013, my lords,
11.
which has been, my lords, the award amount is paid in the year 2020. Notice has been issued in the year 2020, my lords. May I take, my lords, to the.
See, then for the delay, you would be entitled to the benefits attached to the compensation on terms of the, maybe under the Land Acquisition Act or the new Act of 2013. But the question is.
Yes, my lords. My lord, they are not denying, my lord, they are, that is fact, my lord. Since, my lord, the award amount is paid to me, my lord, in the year 2020 by issuing notice to, my lord, these applicants, my lord, the respondent number 1. My lord, from that day, my lord, if my lordship consider, my lord, it is within time. But what they are considering is.
You are agreed by the award?
Yes, my lord.
When was the award passed?
Award is passed, my lord, in the year 2013.
For you to go to the arbitrator?
My lord, only, my lord, after coming to know that, my lord, the award amount is paid in the year 2020, my lord, by issuing a award amount notice. But award amount notice is not in the year 2020.
Let's assume 2020, the amount has been given. You were agreed by the order of by the award.
Yes,
you were agreed, which was passed when?
Yes, ma'am. 2013. Yes, ma'am.
Remember you to go to the arbitrator?
My lord, that is the fact that not they only came to know in the year 2020.
See, this is the issue. And there are a number of judgments, not in the context of National Highways Act, but in the context of the Arbitration Act and the dispute. Invocation of arbitration has to be within 3 years.
My lord, the act doesn't specify, my lord, the limitation is not specified.
Invoking the provisions of the Arbitration Act, ultimately say claim akin to a decade, which is for 3 years. That's how it has been interpreted.
Correct, my lord. But this honorable court not took the contrary view, my lord, even my lord, the mentioned that, my lord.
Right. That's the reason we are saying the issue is pending because it has gone from here only.
At least, may I request, my lord, these are farmers, my lord. Anyhow, my lord, the land has been, my lord, they acquire. At least, my lord, 50% they have deposited. Other 50, my lord, in that, my lordship, they order for 50%. My lord, the security is.
See, we have to balance the equities. We have to also, let's assume you will succeed in the appeal. You will get the next 50 also. No issue on that. In the eventuality, suppose they succeed.
My lord, subject to, my lord, the.
No subject to.
My lord, these lands were, my lord, situated in lucrative, my lord, the locality and, my lord, valuable lands. Somehow, my lord, at least, my lords, in their, my lord, these farmers in house, my lords, they, my lord, they proceeded with, my lord, the family marriages and all.
It's a hard case, you know.
And my lord, I don't think, my lord, they will move before the Supreme Court also, my lord, since.
No, it was listed on September only, my lord, it's adjourned. No, my lord, we are pursuing with that, my lord, there is we have written a letter also, my lord, after your lordship directed last time to expedite the appeal before the Supreme Court, my lord, we have. Yes, ma'am. Only on this issue.
That's at least 25% of not the deposited amount. At least not their work will not be not the held up.
We are only saying is how will you secure the amount, whatever we release. That's all.
Not the, except not of the other, not of the equal security, not any not of the executing bond or not of the.
Yes. What is the
Malad,
response?
Malad, they said that they already addressed the letter to the legal advisor there in the HQ, Malad headquarter to expedite this, Malad. One of the retired Supreme Court judge is the legal advisor, Malad.
Yes. We should provide any security. We don't know how long it will take for the Supreme Court.
That is
Maybe necessity of money. You can give any security.
at least not, if not they moved before the Supreme Court at least specified time, not then not the issue could be not even not in Supreme Court also.
He said they are returning to their lawyer there in Supreme Court for listing. We can give a date, we can see what is the progress made there.
Yes.
Then we will take it, but at the same time, we must also take instructions.
Yes.
Okay, individuality, that may take time, at least you can press your application for release.
Yes.
But we will be seeking any security. They say that the request of counsel for the appellant that the matter is still pending consideration.
Yes.
The issue is still pending consideration before the Supreme Court. From a immediate appropriate to be notified.
Next matter also, sir.
May I request not, at least kindly not the, mention that not they are going to move before the not the Supreme Court, otherwise not every time, not whenever not.
Yes, my lord. We have written to our project director in Bangalore, my lord. He internal. No, based in Bangalore, my lord. He intern will.
Expedite the to file an application to expedite the hearing of the simply pending consideration before the Supreme Court.
Yes.
Right?
Yes, my lord.
You can say.
My lord,
Application.
my lord, I will check, my lord. Get the instructions, my lord.
(16:4).
Great.
(34, 35 adjourned, 36, bill number 36, Lakshmikant.
Your Lordship, we have filed one recovery money suit, Your Lordship. We have supplied the goods to the respondent. And against the goods spent, we have raised 107 invoices which you have produced. And further, the defendant has given handwritten letter, Your Lordship, which has been produced here, two handwritten letters. But the Honorable Court has not considered that, and there is a check was also been issued, Your Lordship. The check is given in the prima facie and is a summary suit. But the Honorable Court has emphasized on the delivery note and has rejected our claim, Your Lordship. In page number 30, Your Lordship, para number 20 of the judgment, the Honorable Court has acknowledged that 107 and 108 are letters allegedly written by the defendant to the plaintiff, acknowledging the liability. No doubt these letters are suggested to be concocted and created documents in the cross-examination of PW1. Degree for money, Your Lordship, money suit. Defendant has filed wakalat and cross-examination, but he didn't come to the evidence witness, he didn't come for the lead the evidence, Your Lordship. So it has been only on based on our this one the judge has dismissed the suit without considering the letter, which is prima facie case that it is handwritten letter by the defendant. 2 letters. Again, in the continuing, Your Lordship, that the PW1, but defendant has not stepped into the witness box to deny that the said letters and give opportunity to the plaintiff to confirm signatures thereupon to the defendant.
Sir,
Therefore,
sir,
it is not possible to accept the
sir.
contention.
$23,400.
Next suit, Your Lordship. Yeah, next is mine. So this is also a suit, Your Lordship, where we have surrendered the services of advertisement for the cricket match for the respondent, and we have invoked an arbitration clause for the recovery of the money due. This honorable court, by referring the case to the arbitrator, Your Lordship, in the page number 37, last para, Your Lordship. Immediately upon the completion of pleadings, the learned arbitrator is directed to decide the issue with regard to mental weight of the claim petition in light of the specific contention urged on behalf of the respondent that the Mr. Mohammed Shoaib was not authorized to empower the subject agreements in favor of the petitioner as preliminary issue. So there was specific direction was given to the arbitrator to frame preliminary issues and pass order on that, Your Lordship, because the respondent was disputing the signature of Mohammed Shoaib. He is not authorized to signature. He is given the designation of marketing director. So because of this honorable court, after appearing after the completion of the pleadings, has passed an award, preliminary order. It's not an award, Your Lordship. In the page number 2, order on preliminary issue has ordered. It is not an award at all. Sorry, Your Lordship. Page number 40, Your Lordship. 39 arbitration order will started. And the next page, it's clearly it's not an award. It is not an interim award also, Your Lordship. On second page, headings, Your Lordship. Order on preliminary issue has ordered. But the respondent has treated this as an interim award and filed an appeal in section 34, which is not maintainable at all. Because it is not an interim award nor an award. It is not it's just an order on the preliminary issue. That has happened, but this honorable court has. Yes, I'll explain the yes, Your Lordship. And in page number 46, the issue was framed by the honorable arbitrator. 46 first paragraph. Whether the claimant proves that the promoter has competency authority to execute the agreements dated 14/6/2018 and 27/6/2018, and that they are. It is decided in our favor that he is authorized. The arbitrator has ruled at page number 81 that he is authorized, his authority, absolute authority, and competency to execute the agreements on exhibit P3 and P4. Yeah, valid, and it is ordered in my favor. But the respondent misinterpreted this order as an interim award and challenged before the commercial court. Then in page number 82, the honorable commercial court.
You say is even this could have been a subject matter of 34. Subject matter of after the final.
Yes, yeah. After a final award only, it has to go to the commercial award. Commercial court.
Not have been at a preliminary stage. Not have been at a preliminary stage.
Yes, Your Lordship. Right. Yes, you are right. Your Lordship, stay the order of this honorable court. I have applied a stay application has been filed.
The effect of stay.
Because the arbitration is not proceeding further with the further issues.
We have to decide. Otherwise, what will happen? The arbitration proceeding will continue.
It's already continuing, Your Lordship.
It is. Are they continuing?
Additional issues is framed, but there is not proceeding with the additional issues, and you want the instruction from the honorable court to proceed with the order.
No, but there is one thing. Preliminary issue the competency of the officer for executing the agreement.
Yes, Your Lordship.
That's right. Which means the arbitration clause is valid.
Yes.
So the arbitration is going on.
But the commercial court, your lordship, you see the page number, last, in page number 95, sorry, 94. What, the commercial court has consequently the award dated passed by the sole arbitrator is set aside. So it is been treated as award only by the commercial court, which
what is the effect of saying so that the award has been set aside? The finding of the arbitrator
is
the officer is competent has been set aside. Does that mean that the officer was not competent?
Yes, that's true.
If that means so, then the arbitration clause is not valid.
But other issues can be framed. The other issues on vicarious liability has been framed already.
If the arbitration clause itself is invalid, how can there be an arbitration?
No, because he is an employee. They themselves have given the document that in the process of the employment, he has executed the agreement. So vicarious liability has to be treated, Your Honor.
No, will that be in the arbitration proceedings or in suit or in a different proceedings?
No, in the arbitration proceedings, because he is an employee.
To make it different, is what we have understood is this. To say that the person competent, the person named is competent to execute the agreement.
Yes.
He is the employee.
He is an employee.
He is the employee.
Employee and
on behalf of the company.
Yes, Your Honor.
On behalf of the company. Yes. So the agreement was valid.
Yes.
That has been the finding.
Yes.
Of the arbitrator.
Yes.
So the proceedings are going on.
Proceedings is going on, but without any evidence, because
that particular finding has been challenged in the 34, which according to you is not maintainable.
Yes. Yes.
The trial court has set aside that finding of the arbitrator.
Yes, Your Honor. As an award, it's treated as an award.
We'll come to that in the later stage.
Okay.
So once that has been set aside, the finding of the arbitrator that Mr. Soya, who had executed the agreement on behalf of the company, was not competent. The effect is that only.
Yeah, that means that.
If he is not competent, then the arbitration clause goes. So he is not competent. We are surprised how these proceedings are going on today before the arbitrator.
No, because of that, we have clearly given that instructions has to be, we have filed an application in CMP for the direction also. In case original CMP 443, what you have produced.
The application file.
Application for direction to the arbitrator to continue with the proceeding, because this is not an award that has been misinterpreted by the Honorable Commercial Court.
But why did you file there? How many proceedings you have filed?
No, but
same thing.
Yes, sir, but it has to be like commercial appeal is mandatory for the commercial order. So it is in the right way. I am coming in, but for instructions and directions, that is not an award, and it has been misinterpreted, but it's not decided yet. It has been filed last week. Now the court may hear it this week or next week. They will come for the vote.
Now read the third line from the top.
The state appointment letter consists of 6 to 7 pages, reading terms and conditions statement.
Internal page 13 of the trial court order. Page 96, running page 96.
Sorry, you're looking at 443, you're looking. CMP order.
No, we are running page, you have running page 96. Take a look.
Yeah, 95 is the last page.
Internal page 19 of the trial court order.
90, okay, sorry, you're right, 190. 19 is the grounds, pleaded. 1919, your Lord, 19.
Page, internal page 13 of the order.
Out of the arbitrator or?
You have a appeal paper book?
Yes, your Lord.
Come to 96 of that.
96, 96.
96.
96.
Page number 96. Page number 96.
96.
For commercial appeal 297. Orders, order.
In my opinion, since the arbitrator did not observe the fact that though this Mohammed Shoaib has appointed as a managing director, he has not empowered with an executive.
Yes. Now come to page 12. See, in between, just in the middle of that page, when a person has been employed for a position of marketing director, having no executive power, is not supposed to execute any agreement on behalf of the employer company. That's the finding.
Finding of the cover.
Of the trial court. So what is the effect? The agreement itself is.
But there are other observations observed by the arbitrator, your Lord. Arbitrator has observed in another way. The viewing of the sea, there may be two ways, but doesn't mean that the appellate court has the power to suspend the complete arbitration award. There is no arbitration awarded. It is a preliminary issue. Let the award be passed, then the final award can be challenged in the commercial court.
How would you come out of this? The finding is Mr. Mohammed Shoaib was not competent.
Yes, your Lordship, but it was not disclosed to us, and there was more. A check was also being given. There is a payment being made by the respondent company in between. When the payment is done, that is when agreement is binding on the respondent. And they have not denied the services of the advertisement also. the arbitrator has discussed it's on MA and MO, memorandum of articles and article of association also didn't discuss. In page number 59, your lordship, the internal page number 21 of the arbitration.
37 was maintainable. Is that order of the arbitration? They could have maintained in 37 rupees. Not be 34. We should notice.
But in MO and AVA, he is having power, your lordship. The arbitrator in page 21 of the internal arbitration award, it is clearly discussed all the powers of the MO and AEA, how the Mohammed Shoaib was competent to give the sign the authority.
See, we are only issuing this on your submission that 34 was not made. But what we are putting it to you is, you may be right on that. But the remedy under 37 was available. That's what we are saying. Just look into this. Okay.
Stop it.
(16.4). Serial number 38, PB Raju. 38.
Defendant's appeal, my lord. The very good.
Kindly come to page 5 issues.
It is last date of hearing, my lord, that they have submitted before this court. And entire amount decreed which they are going to pay, they have requested this court to reduce the interest. Your lordship, my lord, asked me, I have said 4% or 24% can be reduced. That is the submission.
I am not resigning from my statement. I said I am prepared to pay the principal amount with some reasonable amount of interest. I stand by what I said. My lord, the mistake committed by the commercial court is the principal amount is not mentioned properly. The principal amount is 64,36,000. Kindly see the decree portion. The decree portion is 97,83,000. Interest is included in the principal amount. That subject to that, my lord, I will deposit 64,36,000 with a reasonable interest within 4 weeks. Let there be a stay order. I will convince my lord that the decree is amounts to payment of interest upon interest.
No, I'll make submission.
Now, kindly see para 7 of the internal page 5. The issue is this, my lord, whether the plaintiff proves that the defendant is due a sum of rupees 64,36,360 towards supply of steel. This is the principal amount. My lord, this is the invoice amount. When the suit claim was for a interest thereupon on the at 24%. Kindly see the decree, my lord. The decree is 97 lakhs plus interest at 24%. This amounts to interest upon interest. They would be entitled for 64 lakhs from the date of the supply till the date of pendent letter interest at 6%, and thereafter whatever would be the contractual rate of interest. My case is, my lord, that the invoice does not even contain a clause for payment of interest. There are other aspects which I will go into. On the last occasion, I made a submission to this court. I will pay the principal amount.
24/12/2020.
Yes.
On an amount of 64,360.
360, that's all.
Till present date, some reasonable rate of
legal notice.
Yes.
An amount of 24% interest.
Was what was claimed by them.
Thereafter, then which would come to 27,03,271.
Yes.
45. And is also liable to pay interest from 26/9 till the filing of, what was the date of legal notice?
Legal notice is dated, my lord, 26/9/2022.
Right.
Yes.
So till that day, he has quantified 27 lakhs, so 64 plus 27. Then liable to pay interest from 26/9/22 till the filing of the suit, which would come to 64,634,636.
6,40,000.
Right? So till the filing of the suit, the defendant is all liable to pay a sum of 97.
Yes.
So what he has quantified is
till the filing of the suit within 97
Yes,
days,
sir.
267.
Yes, well, this is of two components. One component is the principal sum of 64 lakhs. The second component is interest of 27 lakhs. Now see, now on this 27 lakhs, which is the interest which they have claimed of 24%, that is the decrease for that amount plus 24%. So therefore, my lord,
Just putting it to you for your consideration.
please.
You read that order 55. So that 97 lakhs which has been quantified in those paras which we have read
Yes,
is still the date of filing of the suit.
yes,
That's right.
correct.
Now read in this perspective, paragraph 16, the order. Defendant is liable to pay plaintiff a sum of this with interest from the date of suit till realization. That means now he is coming for future interest. What he has done was pending a life or pre-reference.
Kindly come to the previous page or page 10 bottom. Therefore, for the reason mentioned above, the plaintiff is entitled to recover a sum of rupees 64 lakhs 36,360, being the balance amount due under the purchase order with interest at 24% as claimed in the plaint. What happens is, my lord, when you file the suit, you say X amount is the principal, Y amount is the interest. And therefore, this total X plus Y, Z amount is the suit claim. But when the issue framed is, what is the principal amount? On that principal amount, whether you are entitled for interest amount also, that is how it is. It amounts to a interest on principal, on the interest. They have to, my lord, when a suit is filed on money, my lord, I will now.
Statement of objection, my
My
lord.
lord, I will now.
Prayer which, plaint which I have
I will
produced.
now pay this 64 lakhs within 4 weeks, plus some reasonable amount of interest. There's an execution file.
Want to understand this?
Yes, sir. Yes, sir.
Something this other state 25. In our reading, right, or when we say this order must mean that from the date of the suit till realization, it is 24% per annum, but it should be 64 on 64 on this.
Yes,
What is-
exactly.
So
Yes.
what he's saying is, what has been couched, the manner in which the wording has been given. This 24 must also mean
Yes.
on 96.
Right. That as up to date of the filing of the suit, my lord, calculation has been made 24% interest, which we have clearly stated in para 17 of my statement of
So we
objection.
can do this.
Yes, my lord.
64 is the base amount.
Yes,
Okay,
yes,
from, if you just go back
please.
to that paragraph.
From 24/12, 24/12,
So from 24/12/2020
Yes,
till date,
yes,
he will compute interest at the rate of 24%.
Please.
24%. If you are at item, so that 24% even till date would be on the amount of 64,36,360. No difficulty?
no.
Very good. Now tell us,
My,
what is your submission?
my respectful submission is this. As far as calculation is concerned, 64,36,390, which we have transferred, which is admitted in the, before the civil court, commercial court, saying that it is transferred and I have placed purchase order and he has agreed to supply material. Thereafterwards, he is holding without supplying material, which is admitted fact. Apart from that, interest which is calculated from, my lord, 24/12/2020 to 26/9/2022, date on which that notice has been issued for 27 lakh 0327. Thereafterwards, after notice to till filing of the suit, 6,43,637, total comes to 97 lakhs. My lord, my respectful submission is, in the entire cross-examination place has been placed before this court, and they have admitted none of the documents which they have produced is pertaining to this case that they have admitted. This is not pertaining to this case. And they have admitted that I have placed purchase order, and they have admitted that I have transferred money. They have admitted before the trial court saying that we are illegally holding that.
Now, tell us one thing. Are you contesting this case also, the finding also? That they are not entitled to 64,360 and interest at the rate of 24%. Are you contesting?
Initially, I did contest the issue of 64 lakhs 34,000 was not due to them because he himself was an agent of my principal purchaser. My principal purchaser was due about 1 crore and odd rupees to him. When I stopped supplying steel to him, he sets up his employee, and this one single invoice is sent to me. One single purchase order is sent to me. The supply of the steel is to the same
Place.
project work, same site. Nevertheless, the court is right in justifying that I cannot link that and this. Therefore, I'm due this amount. I will pay this amount. It took me 3 years to recover that 1 crore 83 lakhs from his principal. That apart.
Okay, now 64,360.
Principal.
Now only on the interest aspect.
Yes, the purchase order does not contain any clause regarding payment of interest. First aspect. My lord, it's blank. There is no contractual amount to pay interest. So some reasonable amount of interest, I'm making that submission on the last occasion, I'm making it now also. I will pay that amount within 4 weeks. Let there be a stay of the execution because they're pressing the execution.
Now what do you say on interest?
Insofar as interest, this is commercial transaction that I, with a belief that they are going to have placed purchase order, and they are claiming some third person as my principal, where I have made a contract. This is nothing to do with, this amount is nothing to do with that which is admitted by them. They have not placed any material before this court. My respectful submission is that I have borrowed money. This is a commercial transaction. I have deposited to them. Therefore, my lord, I'll leave it to this honorable court. 4% interest can be reduced if they are paying immediately.
No, only.
No, nothing. That is false statement.
Please. I recovered that money after filing execution after 3 long years.
How much you got?
Only principal amount.
Pardon?
Only check bonds.
After I had to file check bonds cases, only that, whatever principal amount I recovered. My principal. This
financial position could not get the interest.
They set him up. That is a different story. It doesn't matter. This
something the submission which he has made.
I
minus 4. What you say?
No.
What did you say?
24 minus 4, 20%.
No, less.
Yes.
I've paid 9% interest for it. But that is what I'm getting. For myself.
See, to what you say. Purely the interest component varies from contract to contract.
Yes, ma'am. This contract did not contain because the fact that this purchase order did not contain an interest clauses, the reason it supplants my theory that he was set up by his by my person who was due. 9%.
I want to sit together and work it out what is the interest if this is the narrow purpose. Just think over, take instruction, come to an agreed figure.
I do understand what my lord said. What I'll do is, this 64 lakhs plus 9%, I'll deposit within 4 weeks. We'll come back.
4 weeks.
Yeah, let him get the money.
There are 5 years now.
I thought.
See, only narrow purpose. You can get settled. It's only you have to come to an understanding on interest. We don't understand the deposit, then matter pending here. Don't understand. Come to an agreed terms. You will have it a day or two after. Discuss among yourself, take instruction. Just hold it off. Come to a figure. This need not to be. See, this is the only issue. I don't think admit and now lying here. Come to a conclusion so that there is a finality to the issue. Okay, when do you want?
2 weeks.
Day after tomorrow.
10 days. 10 days.
10 days. 10 days.
Execution date.
Execution petition, my lord, that we have filed, but my lord, the earlier we have
29/3.
intimated.
29/3.
Execution date, my lord, has not-
29/3.
29/3. Yes.
Just so that we have heard the answer for the, shall we record? We are putting it
Yes,
in
ma'am.
that 64,36,360 is an undisputed amount which is payable by the respondent.
Yes.
Please,
Yes, yes.
Idea according to the respondent. The only thing is
Interest.
on interest.
Yes.
When we say you want to,
Please.
we have heard the legal counsel for the parties for some time. So during the course of his submission, the legal counsel for the appellant considered that an amount of rupees 64,36,360 is due and payable by the appellant to the respondent as a principal amount. His only submission is on the interest granted by the trial court on the said amount. The legal counsel for the party states that the matter be deferred by 10 days to enable the parties to work out, if possible, to come to an understanding. To make an attempt to come to an understanding. We say nothing on that. We don't come to an understanding, we will listen. If the federal request, we will notify.
27th.
Normal, well,
27th, sir.
27. Thank you.
Please.
Much.
That they are given an undertaking that they want precipitate the execution.
No, he has said so.
Yes.
He has given himself a day.
And advance not in terms.
39, Shri Devendrappa.
Yes.
On correspondence.
This day that notice to the respondent to
Yeah.
has been put
I'm a person I respond about 2 mailers. I recently have heard of a call that.
Four. Serial number 40. Serial number 40.
Or appellate wishes. The delay, my lords, of 123 days. But that was for the reason that, my lords, I filed an application seeking clarification of the order of the London single judge. That got dismissed, my lords, I preferred an appeal. Lords, what happened, my lords, the London single judge, my lord, the charge against me was that, my lords, I printed receipts in, my lords, in respect of checks which were dummy, giving the false numbers. Lords, I was, my lords, inflicted with penalty of removal. Lords, however, what was not noticed was, my lords, the letter of the branch in charge, who said I am not involved in the misconduct and I should be exonerated and I should be cleared of it. Then a single judge, my lords, records that and said that got unnoticed, and as such, the penalty should go. However, my lords, what the learned single judge does is, my lords, he treats that as, my lords, compulsory retirement. My lords, from the date, my lords, my memorial in so far as the penalty was considered, and my lords, in spite of, my lords, the actual date of superannuation, which was in 2016, my lords, grants compulsory retirement from 2003 onwards, for which there is no justification. And, my lords, I'm not even held entitled to, my lords, the back wages. That's the reason, my lords, I sought, my lords, a clarification, which the application was dismissed. My lords, the appeal, such, my lords, is preferred. No, my lords, against the main order itself. Lords, kindly have a look at. Yes, my lords, yes, my lords. Seeking for clarification that got rejected, my lords. I was waiting for, my lords, the result of that got rejected on 5/3/2024. Well, that I have not produced, my lords. However, my stated my lords in the affidavit.
They to challenge that order.
No, no, my lords, no, my lords. Anyway, my lords, if the order on the main petition is set aside, but probably that would serve.
There is a,
I think your point is clear.
If lords kindly have a look at, my lord, the order of the learned single judge.
there is one submission, Your interpretation. Sorry for the interview. We are also prefer the appeal in the same order, against the same order. Please, Your Honor. The writ appeal number 22 of 24. Connected with this, it may be listed and we will have both.
My lords,
The date is not.
the instruction what I have, lords, if lords kindly have a look at, my lord, the case status, my lords, of their appeal. It was, my lords, adjourned on 5/11/2024. Lords, granting some time, my lords, and that is 9/12/24, granting 2 weeks time, filling which the appeal will be dismissed.
That
However, it
application,
appears, my lords, on
application is also
10/1/2024,
filed.
it was again listed for non-compliance. And afterwards it is.
There is only one clarification, because it's a final order, 4 respondent has made as a parties. But in the appeal memo, there is only petition, only the 3 members are the respondent. For that clarification, we have filed the application for the certified copy of the petition, main petition, because we are also please, please. Please.
I believe, lords, but the difficulty is, I'm without pension, lords, though by superannuation, lords, lords, I am entitled, but the date which is reckoned is of 2003, lords, whereas 2013, lords, I superannuated in 2016. 3 years of service, I lose back wages, please.
See the quantum which varies between 2003 and 2016.
Secondly, lords, I'll be, lords, having, lords, a stigma of, lords, getting inflicted with a penalty, my lords, that. Please. Lord, monetary, lord, issue is one aspect. Lord, the other issue is, lord, there is a.
You are saying so.
Please.
I am not saying that we are dismissing this appeal. We are awaiting that.
Please, lord.
Just say that. Just say we notify this appeal. So we will be approved.
23-4.
Your lordship may call this matter along with the other matter also. Please. Please.
We will have it possibly, if we want to get it listed,
If not, if I can seek notes for a shorter accommodation. I'm without pension notes, without any financial support. This is it.
Let's assume we pass any order, they will come to their appeal, what will happen? Let's have both together.
Only the endeavor being not see a shorter days is given. Probably they'll also make some effort to get it listed, my lord. That's please.
41, the Aditya Narayan.
My lord, I appear on behalf of the appellant, my lord. My lord, this appeal is preferred, my lord.
Yes, Mr. Arvind.
Against the final judgment and order in a writ petition. Your lordship may kindly see the directions issued, my lord, at page 109. Writ petition is allowed in part. NLSIU, that is, my lord, the appellant, is directed to implement the directions issued by the Honorable Supreme Court in Nalsa's case by formulating reservation along with measures for providing financial aid to TGs. TGs, my lord, is transgenders. In education from before commencement of admission process for the next academic year, until then, to provide reservation of 0.5%, half the percentage of reservation provided for TGs in employment under state as interim reservation with fee waiver, and for which NLSIU may apply to state central government for appropriate grant. My lord, the writ petition was filed, my lord, only for, your lordship may kindly see the prayer in the writ petition for a minute. All these, my lord, relating to finances, all comes subsequently. Your lordship may just see the prayer in the writ petition at page 56.
Yes.
The order that a single judge, my lord, extracts the prayer. Issue an appropriate writ order or direction to quash the decision the first respondent number, to quash the decision respondent number 3, not offering admission to the petitioner as contained in petitioner's scorecard issued by respondent number 3, placed as annexure L, while application number so and so. Issue an appropriate writ or order direction to the respondent number 3 to provide admission to the petitioner in the third year LLB course from the 2023-24 academic year. 23-24 academic year, my lord, commenced, my lord, in June of 2023.
What is the position thereafter, Mr. Raghavan?
My lord, the position, my lord, is nothing much, my lord. I mean, we
No, this
offered admission. There was an
Order
interim
has
order.
not been implemented.
My lord, no,
ma'am.
no,
You are
one
in the
minute.
appeal.
My lord, order was implemented.
Implemented.
Yes, yes, I tell you also what happened. In fact, the learned signature records that the order was complied with. Now, my lord, what we said was, look, come and join the course, but this is the fee. Then, my lord, having accepted the fee matrix, the petitioner, my lord, filed an application for amendment of the writ petition saying, no, this financial concession that is being granted is not adequate. I want more financial concession. That application for amendment is still pending, not allowed by the learned signature, but directions are issued in the main order.
No,
In the
amendment
meantime,
of
my
the
lord,
writ petition.
yes, my lord. Yes, my lord.
How is the, now what is pending there before the?
Well, nothing. I mean, even without the application for amendment having been considered or allowed, the learned single judge has given directions with regard to financial aid also. And the interim order was complied with. Your Lordship may kindly see, my lord. We, after the interim order was passed, we did offer. Kindly see, my lord, page 387.
But Mr. Raghavan, this order says writ petition is allowed in part. That's mean final determination.
Yes, yes. Without, my lord, the application for amendment being allowed.
Is any application pending?
My lord, yes, my lord, that application has not been allowed.
My lord, it shows that writ petition is disposed of.
This petition is disposed of.
Disposed of.
My lord, writ petition is no doubt disposed of, my lord. But in the writ petition, the prayer was confined only to admission. Thereafter, my lord, when admission was offered, we said this is the fee matrix, so far as the National Law School is concerned. Then, my lord, an application for amendment was made, saying, no, I can't pay this fee. Please direct the National Law School to give concession, fee concession. We said, sorry, that cannot be done. The whole writ petition is only for admission. Fee concession is a matter of policy. It cannot be a matter of mandamus. Now, my lord, that application was kept pending, but the writ petition has been disposed of, giving a direction with respect to fee matrix. And in the meantime, my lord, I tell you, Lordship, given an admission. There are two interim orders, my lord, that your Lordship may kindly see. Please see the interim order that was passed. After all this, my lord, please be kind enough to turn to interim order dated 1/2/2024.
Just take that, ma'am.
In fact, learned single judge says the whole thing, so far the admission is concerned, it has become academic. The only reason why the writ petition was kept pending was to ask the state government, what have you done with respect to your transgender policy?
Now, this is the only issue now. Mr. Raghavan, then now today admission has been given.
My lord, admission.
Concession.
Only, and today, my lord, admission also is not, the petitioner did not take the admission.
Have you taken the admission?
No.
Just 1 minute. Yes.
My lord, the position, my lord, is nothing much, lord. I mean, we offered admission. There was
Order has not been implemented.
My lord, no. My lord, order was implemented.
Implemented. Just 1 minute, Mr. Raghavan. Just 1 minute.
Records that the order was complied with. Now, my lord, what we said was, come and join the course. But this is the fee.
What is this
That, my lord, having accepted the fee matrix,
I'm just leaving the meeting.
Just 1 minute, Mr. Raghavan. Yes, tell us one thing. Now, have you got the admission and you have taken the admission?
Sir, I received the interim order on 22nd.
Just switch on the mic.
It's on. I received the interim order on 22nd, 8 August.
This is not an interim order. This is
No,
a final order.
this is 16/12/2024. The interim order, which they have not provided in the memo of appeal, is part of my statement of objections. It was a detailed order of 24 paragraphs. The writ petition was filed after I was summarily denied admission by NLSIU, even though I had achieved 96th percentile and 83rd percentile in their Part A and Part B after applying very clearly under the transgender category. Now, they did not respond to my emails raising questions about it and asking them to reconsider the decision to not grant me admission and the reason and so forth from June 12th. After that, I filed the writ petition because they had not even published any rank list or anything like that. They had not published any rank list or anything, and they denied the admission. The learned single judge at the time of the interim order considered all factors that had been placed at the time of the writ petition, which was pertaining to quashing the decision to not grant me admission. And he was pleased to give the interim order dated 22nd August 2023. The next day, I made the representation and visited the college and asked them to prepare the procedures for admission. And they did not comply till 28th. In that pendency, they also went for a writ appeal against the interim order. Then on 28th, when that appeal did not succeed, on 28th of August, they granted me an admission letter, which was a full admission letter, full procedures, which is under the interim order, which is still they're challenging. They have given me the against the interim order, which says admit the petitioner if found eligible. So they had no challenge to the eligibility. They granted me the admission letter, and on 29th itself, I paid 50,000 as.
Tell us one thing simple.
Yes, my lord. It's not that simple. They have made it complicated.
Will you hear the court?
Yes, sorry.
Surely, no, you'll hear the court.
Sorry.
You are concerned with your admission?
Yes, very much.
Yes or no?
Very much.
That's right. Now, what about the fee concession?
That has been granted through the final order.
Mr. Raghavan.
My lord.
Now, is the institute ready to give him to the admission?
My lord, there's a difficulty today.
Pardon?
There's a difficulty. The petitioner, my lord, did not apply under any reserved category, and there is no reservation for transgender.
No, that's on fee concession, Mr. Raghavan.
No, my lord. I'll come to on admission. On admission, I'll tell you, lordship, what the problem is. My lord, petitioner did not apply under any reserved category. The petitioner, my lord, applied under general category. And,
that's right.
And as your lordships are aware, my lord, admission to National Law School is regulated by those admission tests. And the petitioner did not qualify in a general category. That is the category under which the petitioner applied. Therefore, my lord, the question of granting admission did not arise. But anyway, my lord, interim order was passed by this honorable court. And your lordship may kindly see, my lord, what we did even as of 28th of August 2023 now. And now, my lord, for that, admission was for the year 23-24. And now, my lord, we have already spent 1.5 years.
No, but in any case, Mr. Raghavan,
my lord,
we just want to know principally whether the institute has decided to implement the order of admission. Yes or no?
The order of interim order, my lord?
The interim order or even this order of the final order here?
No, my lord, final order we are challenging. We are not, we are, in fact, my lord, I tell you, lordships, there's something more I want to tell you, lordships, my lord. In fact, when this interim order was, we offered admission pursuant to the interim order. They said, this is the fee that you have to pay. Petitioner said, I cannot pay. Then, my lord, there are further interim orders passed by the learned single judge. I want your lordship to kindly see that. Your lordship may kindly turn, my lord, to the interim order that has been passed on 1/2/2024.
Yes.
May I read that, my lord? Kindly see it. In fact, learned single judge himself said this whole issue on admission has become infructuous. I'll read that. Upon hearing learned counsel for the parties for some time, it would appear that it was granted on 22/8/2023, directing respondent number 3 to admit petitioner to 3 years LLB course for academic year 2023-2024 may have effect of rendering all other prayers except prayer C, direction for implementation of state policy on transgenders, academic, especially after an unsuccessful challenge against the interim order before the division bench. Unfortunately, as it appears, petitioner claims inability to pay fees of LLB course as demanded by respondent on account of precarious financial conditions. While on behalf of the petitioner, it is sought to be contended that the mere provision for reservation of seats for admission in favor of transgenders or adoption of measures for sensitizing against discrimination or interim order directing admission and petition in this case may not adequately address problems faced by transgenders without adequate provisions for financial assistance. It is submitted on behalf of the university that all possible assistance within available legal framework was offered to petitioner, and petitioner could not make out any grievance against the same. The petitioner accepted it. It is further contended that academic session of 3-year LLB course having commenced, even if the petitioner does pay the fee, now duration of remaining academic course would not be sufficient to enable petitioner to meet minimum attendance requirement mandated under the university regulations, and as such reliefs were rendered infructuous. However, it is seen that the petitioner has also espoused the cause of non-implementation of the Karnataka State Policy on Transgenders 2017 Annexure T framed by state government, which mentions of provisions for financial assistance, etc., and application is filed by the petitioner for amendment of petition for seeking financial assistance, etc. Under the above circumstances, while being conscious of the submissions by respondents number 3 and 4, it is deemed appropriate to direct respondents number 1 and 2 to disclose the manner of implementation of policy at Annexure. That is respondent number 1 and 2 is the state. At Annexure T, whether transgenders can avail financial assistance, and if so, to what extent and manner of availing such financial assistance offered, etc., with adequate particulars to be stated on affidavit by next date of hearing fixed on 19/2/2024. Therefore, Manan Learned Singh has recognized that the whole prayer relating to admission has now become academic, because the 1.5 years have passed, the admission was offered, they did not take it because of the fact that the fee was not paid, and so the whole writ petition was confined only on the question of whether what is the state government going to do with respect to implementation of the policy on transgenders. Now, Malon, we now are faced with this, Malon. So far as I am concerned, the petition came to an end. It is not a public interest litigation.
So what you are saying is, since he did not take the admission on the earlier occasion, now the admission cannot be given because he will not meet the attendance requirement.
Exactly. And now, Malon, they got to go through a competitive examination. And another division bench of this court has taken the view that insofar as NLS is concerned, which is governed by a special statute, the ultimate body is the executive council and not the government. And the executive council has to take a decision.
Just 1 minute, Mr. Raghu. Now tell us. First, why didn't you take the admission?
I applied, I took the admission as per the interim order. I gave 50,000 as security deposit, and they in the admission letter dated 28 of August, they had said you need to indicate if you require financial aid, which immediately after paying the security deposit, I indicated that I need financial aid and hostel accommodation, and they then proceeded to share the financial aid form, which is not part of their public domain. I then proceeded to complete the financial aid formalities form, and through which I very clearly at every stage, my lord, I explained that I am a transgender person who faces homelessness, extended periods of unemployment. I have no family. I have no social security, no wealth, no assets, through various modalities that were available to me, which was not available in the form itself, because the form is only directed at people with families. So I provided additional information, and then they returned the decision that I should raise educational loans. I responded to that email asking them for time to raise the funds and simultaneously complete the admission procedures, to which they did not respond for 1 month, and then summarily rejected my request for extra time.
Is there any communication from them after the interim order?
Yes, all the communication.
Calling upon you to take the admission?
They sent the admission letter, that's it.
Where is that?
20.
My lord, kindly see, my lord, the letter at page 387.
Yes.
$387.
Then, Mr. Raghavan, why did you write this letter when you are really contesting the very directions of the learner single judge?
No, my lord, this was during interim order. We wanted to comply with the interim order.
You're right. Interim order means once he gets an admission, where is the question of, the admission getting cancelled?
He didn't take it. Well, the problem is the petitioner did not take the admission. Petitioner said, I can't afford your fee. Give me financial concession. We offered financial concession also. Kindly see, my lord, what we have done. Please see, my lord, the financial
No, there are
concession.
two aspects of it.
Yes.
Admission without any financial assistance.
Yes.
Okay.
Yes.
That is agreeable to you?
Not today, my lord. Now it is because she has missed the bus. The petitioner has missed the bus.
My lord, may I?
We can't do anything about it today. And today, my lord. And there's a difficulty about it.
The
whole
submission which is
yes.
submission which is sought to be made is this.
Yes.
It is the university which sought whether there is a requirement for financial aid, and
Yes.
possibly that made the candidate, maybe fill up the form and go with the university with regard to the financial aid. It later transpired that the financial aid cannot be given.
No. Financial aid was given. So no, my lord, that's the point. Please see, the financial aid was given. Kindly turn to page 442. No, petitioner wants some extra. Kindly turn to page 442, my lord. May I read this for your lordship's kind consideration? The Financial Aid Committee has carefully reviewed all the information provided in your application and the supporting documents. Considering that you are a postgraduate student and have been working for a few years after graduation. So, all this statement about I don't have money,
The three you would see, it's
Yes.
basically primarily an education loan.
Yes, we are saying we gave them a list of banks also, and we said we will take the burden of interest.
I am not eligible for education loans.
What according to the candidate is, the candidate is not eligible for
And
education.
all of this.
Maybe
has
so,
been-
that is something that what can we do about that? I mean, this is our policy on financial aid.
Okay,
My lord,
very well. I think we'll look into the larger aspect of it also.
my lord, this is not.
And this is not a public
this is
interest
not an
litigation,
issue of
Just
technical.
1 minute, Mr. Agrawal.
This is
Yes.
not an issue of technicalities that they have been raising since the beginning of this petition, my lord. If you look at the course of events, it is, I filed the petition, I file an application, they file a statement of objections. They are not clearly here mentioning that after the daily orders that they have submitted, there is another daily order dated 22 November, where I had filed a rejoinder a detailed rejoinder to the objections that they had raised pertaining to my financial aid application.
But tell us one thing on a larger issue.
Yes.
But there has to be a common criteria for making admission to the university, no?
Yes, my lord.
But did you went through those?
I went
process?
through all the procedures, and if you may please look at,
Subject to you meeting the benchmark.
They did not. Petitioner did not.
I have gone beyond the benchmark that they.
No, that's not the case, madam. That's not the case.
75th percentile is the mandated percentile. I have got for general and reserved. I've crossed both categories.
My lord, that is not the case. That is not the case.
My lord,
Put forth
please,
before the learned
Just
previous
1
batch.
minute, Mr. Agrawal.
Please-
Let him, just
please-
1 minute, please.
Sorry,
Yes.
please turn to, I'm sorry, my lord, it's been 2 years of trying to, not 2 years, 5 years of trying to get into education as a transgender person. Please turn to page 33 of my statement of objections. That is the interim order that was passed. Para 18, 32, page 32, para 18, if I may please read it. Right to equal protection under the law is extended to every person, which includes the male, female, and third gender within its ambit. So the transgender is also entitled to legal protection under the Constitution of India in all the spheres of state activity. The triumvirate exists between Articles 14, 19, and 21 of the Constitution of India. All these articles have to be read together. Any law interfering with the personal liberty of a person must satisfy a triple test. It must prescribe a procedure. The procedure must withstand the test of one or more of the fundamental rights conferred under Article 19, which may be applicable in a given situation, and it must be liable to be tested with reference to Article 14. As the test propounded by Article 14 pervades Article 21 as well, the law and procedure authorizing interference with the personal liberty must also be right and just and fair and not arbitrary. If the procedure prescribed does not satisfy the requirement of Article 14, it would be no procedure at all within.
Then we will hear you finally. I think Mr. Raghavan will set up for hearing, we'll fix a date.
Very well.
Clear. Now, are there any proceedings
My lord,
to
in the
be
meantime,
pending
my lord-
before the learned single judge?
Yes, my lord, yes, my lord, the problem is that there are directions issued. Please be kind enough to see the directions
What are
issued
the
by learned single
proceedings
judge.
pending before the learned single judge?
Nothing. No proceeding are pending.
There are no proceedings.
No proceedings. No
The-
proceedings.
the,
are pending.
My lord,
Application?
That
they are
application, my
claiming
lord, was not disposed
We
of.
want straight answer. Any application pending, yes or no?
No.
No, my lord, nothing is
It
pending
no
today.
proceedings are
No,
pending.
no.
So we can hear it. Now
Yes.
your challenge is to the final very
Yes, my lord.
disposing the writ petition.
Yes, my lord, and kindly see the directions issued. I mean, this will completely upset, my lord, the character of the National Law School, which is completely merit-based. And, my lord, the law laid down by the Honorable Supreme Court is that reservation is not a matter of right. Reservation has to be granted on the basis of a macroeconomic factor. There has to be a commission appointed to find out. That is what Supreme Court has said in Balaji's case. Even with
Right.
respect to Article
That's-
15.
my lord,
Even with respect to Article 15, the Honorable Supreme Court says, my lord, that there should be a investigation. Why 0.5%, my lord? Kindly
But
see
tell
what
us
is
one thing,
my lord,
more often, like the candidate here, he wants to, pursue his law examination from a good
Yes.
university like this
Yes.
university.
Yes.
What is the way for admission to such a candidate?
The way for admission, my lord, is for the Executive Council, which is the supreme authority as held by this Honorable Court in a matter, my lord, arising relating to National Law School, and National Law School, the government cannot interfere. This is a decision that has to be taken by the Executive Committee, which comprises, my lord, of legal luminaries.
No
Under the
decision to what
statute.
extent?
They are the ones.
No decision
Well,
to
that's
what
we don't
extent?
know. They don't.
No.
To the extent whether or not reservation should be granted to transgender. Second, if so,
Okay.
how much?
Okay.
Everything.
my lord, if I may.
Everything has to be decided by the Executive Committee. And kindly see, my lord, the reasoning given below is single judge. Please be kind enough to turn, my lord, to paragraph number 61 at page 108. The order of the learned single judge contradicts itself. May I read page 108?
No, we'll
paragraph.
set out, we'll hear you, Mr. Raghavan. I think.
Yes, my lord. In the meantime, your lordship may state this order, my lord. That's my prayer.
Just file your submissions, both of you. You
Lord,
also
I've-
file it.
Yes, we will.
Filed
We will.
my
We will.
preliminary statement of objections I have filed.
So that would suffice?
If,
No,
if
if you want to add on anything more of a legal submission, you add. Okay,
those are also legal only.
very well, we don't know any judgments in support.
My lord, that is exactly what I am trying to.
Are the judgments on record?
Yes, my lord,
Very
the
good. We'll look into it.
entire
So,
matter
Mr.
has been
Raghavan, then
heard.
you will file your brief note of submissions and whatever judgments you want.
Yes, my lord. We will.
If I may, I would like to point out that this is also an attempt to delay me from
are
get,
fixing a
no,
short
no, my
date.
lord, please, this is the,
Minute, please.
this is the academic calendar for this year that is available on their website. Please ask them when exactly the current academic year ends, because with the interim order, they did not have any legitimate challenges. So they delayed it on the basis of me not paying fees. And now they are saying this current year
See,
will also pass.
we will fix up. We have to decide a larger issue. And in any case, insofar as your apprehension that this academic session would be over, that's.
I don't know. They have not informed me exactly when it will
Very
get.
well, whatever is this date, whatever you have given here.
That is March is the next
March 25
trimester.
also. We will look into it. We will look into it holistically. We will decide. We'll fix up a date here. Just say that list this writ petition for hearing on. Just give it in first week of March, ma'am. And say at 2:30. Any date, 2:30.
6th of March at 2:30.
Full stop. Mr. Raghavan and the senior counsel appearing for the appellant states that he shall file his note of submissions along with the judgments he intends to rely upon before the next date of hearing. Full stop. Next.
Yes.
So say we also take on record the submission made by, what is your status in the appeal? Which respondent?
One.
Respondent number one. Are you respondent number one? Respondent number one. Is it state? No, two is state.
Lords, respondent number one is, my lords, the writ petitioner. My lords, I'm assisting Mr. Raghavan. I'm the counsel on
Respondent
record
number
for
one
that.
states that the pleadings which he has filed shall suffice the requirement of written submissions on his part. The statement is taken on record, re-notified date fix. We'll have it.
My lord, in the meantime, your lordship may stay, my lord, because the whole matrix will get affected now. Because, my lord, the matrix and the seat matrix, and kindly see the order passed by the learned single judge. My lord. Kindly see what the learned single judge has done. My lord, this is a drastic order that has been passed.
Well, and Mr. Raghavan, we are considering the whole issue now.
Yes, my lord, but there should be no contempt against me. I don't want as a national law school.
And we take it, there are no proceedings before the single judge.
No, my lord, there are no proceedings.
Everything is before us.
Yes, your lordships are right, my lord. But my only point, my lord, is this: that as a national law school, I don't want to face a contempt. That's the only answer. Right. As a national law school, I don't want to face contempt. Contempt.
Right. Who is filing? Are you filing contempt?
Yeah, let them not file. That's all that I want.
Lord, if I had to file, I would have filed back. I have been going repeatedly behind them to get me their admission.
Well, the petitioner missed the bus.
Given 6th March, Mr. Raghavan. It's all right.
But in the meantime, my lord, your lordship may kindly see, my lord, what the problem is.
1 minute, Mr. Raghavan. Just wow,
yes,
please.
Yes.
Are you filing contempt?
No.
He doesn't want to file it.
I have
contempt.
Please record it. That's all that I want.
Making representation since the last day of judgment.
Keep your hands off. We will look into it. We will decide you. We will hear you on 6th of March.
Yes.
Come at 2:30.
Yes.
Please record it, my lord, so that on record.
All right,
Lord,
Mr. Raghavan. If any content fine, please file an application. We will look into it then. We will take his submission on the face value. We will take it, Mr. Raghavan. He says so.
I am not.
We are
my lord, that is the petitioner,
right.
my lord, saying it.
You have heard him.
Yes.
You can ask him to repeat yes again. Repeat.
Yes, my lord.
That's it. Okay. Next.
State is also party. Directions to state government also. Let them serve a copy of writ
We will
appeal.
look into everything, ma'am.
My lord, we have not received the writ appeal copy. That's
But
it.
you have filed your objection before the learned single judge.
There was only direction insofar as implementation of the policy was concerned.
That's right. That directions, this thing is there now.
Please, my lord.
That objections are there.
Please, my lord. Let them serve a copy of writ appeal. That
Lords,
is-
I'll serve. I'm sorry, my lords, I'll serve
Serve
a
a
copy.
copy of the writ appeal.
We would have served. I'll serve a copy, my lords. I'll make sure a copy is with them.
Now, tell us one thing, State of Karnataka National Law. Who appears for 4? Mr. Raghavan, what is this? If you see the memo,
Yes, my lord.
who is respondent number 4? The same university again.
Lords, in the appeal, my
We
lords,
will respond. In the appeal, my lord, appellant is the National Law School, and my lord, the respondent number 4, my lord, because there were 2 respondents in the writ petition. Therefore, as a matter of fact, to make them also. That's all.
Okay. Okay. Yes, next.
42.
Expect to appear for the petitioner in this matter, madam.
Yes.
Lord, this matter pertains to the removal, dismissal from the services of the petitioner. Thereafter, he had filed an appeal which came to be rejected, and both of them had been impugned in the OA before the Honorable CAT, my lord. And there was an order in my favor for reinstatement with back wages. My lord, thereafter, the respondent approached this honorable court, my lord, and the matter was remanded back to CAT, my lord. My lord, thereafter, what happened? In the meanwhile, he had been reinstated into the services because there was no interim order of stay on the order of the tribunal, my lord. Thereafter, my lord, the tribunal states in the order, my lord, may kindly take annexation page 164, my lord.
It's basically on back wages.
Back wages, my lord.
The period is?
My lord, between 2010 to 2014, when he was prevented from
10
services.
to 14, huh?
Please, my lord.
Only this period?
Only that period.
Now, what happened during this period?
My lord, I was out of service.
I had made an appeal to the competent authority of the respondent. They said that appeal did not come. Finally, it was proved that the appeal had come and they decided the appeal. And I approached the Honorable Tribunal, my lord. The tribunal passed an order in my favor for reinstatement with back wages and all consequential benefits, my lord. And that was challenged before this Honorable Court. And the matter was remitted back to the CAT along with other matters, not on merits, my lord, but for fresh reconsideration, my lord. Thereafter, what happened?
When were you reinstated?
My lord, in 2014, my lord.
2014 only?
14, yes, my lord.
Okay.
My lord, my reinstatement is at Annexure A5, page 160, 12/11/2014.
Dismissal order is which date?
My lord, dismissal order is 22/4/2010, my lord.
What was the reason for dismissal?
My lord, there was an allegation of sexual harassment against me. I was a whistleblower. I stated that there is large corruption going on in the company. I brought it to the knowledge of this one. They hoisted a false case against me, my lord, and no charge sheet was issued. Without a charge sheet, a so-called inquiry was conducted.
That would be now it is the complaint itself is a charge sheet.
No, my lord, it cannot be so, my lord. As per the rules of the company and as per the judgment of the Honorable Supreme Court, it should be done as per the rules of the company.
Even in POSH Act, what is the position?
My lord, the POSH Act says that it should be done under the. My lord, may I also kindly take
Very well. We'll come to that.
Please,
later.
my lord.
Now that has been quashed when?
My lord, that came to be quashed in 2014, my lord.
Then that resulted in your reinstatement.
Please, my lord.
Okay. Now after the remand, what did the tribunal did?
My lord, what the tribunal did was this, my lord. My lord, at page number 164, at Annexure A7, my lord. My lord, after hearing the matter, my lord, my lord may kindly take page number 166, paragraph number 6, my lord. The necessity for us to deal with the merits of the case is obviated on account of a development that took place during the pendency of the OA. The applicant submitted a representation with a request to reinstate him. On a consideration of the representation, the first respondent reinstated the applicant through order dated 23/10/2014. Therefore, the order of punishment and all other proceedings in relation thereto becomes non-est. The Honorable Tribunal holds that the order of punishment and the proceedings becomes non-est, my lord. Then I make a request, my lord. Their say is that no work, no pay, my lord. That is the stance taken.
Otherwise this period is being treated for all purposes?
For all other purposes, my lord. Only for back wages I am.
Now, what is the reasoning given by the tribunal?
My lord, the reasoning given by the tribunal is this. My lord, may kindly take page number 65, my lord. Paragraph 16, my lord. Even to claim salary under the aforesaid FRs do not apply to me, my lord, company. My lord. Reinstatement made based on the order of the court after adjudication of the matter on merits is necessary. The applicant was not exonerated from the charges leveled against him by the orders passed by this tribunal or the Honorable High Court of Karnataka. This is what is the contention, the reason, my lord, that I have not been exonerated. That cannot be, my lord, when the tribunal itself holds that the punishment and all proceedings thereof have become non-est, my lord. Please, my lord.
So there is the question of termination being there.
Please, my lord.
Right. But what is the consequence to what is being said by the tribunal? It appears to be this on this. Then there is no sort of an honorable acquittal.
Please, my lord.
If that be so, then they are giving a
no, my lord. My lord, when I initially challenged it before the Honorable Tribunal, my lord, I take various contentions, including violation of principles of natural justice, when the complainant herself says that I was forced to sign the complaint, that I have brought it on record. On merits, it was held in favor of me by the tribunal, my lord. But because of the intervening circumstances, I was reinstated. And because there was no order of stay of the tribunal's order, my lord, they reinstated me under that this one. And because of that, my lord, no, my lord, I had not filed. I requested them reinstate me, my lord. And after that, because there was no stay, they reinstated me, my lord. My lord, notice may kindly be ordered, my lord, valuable this one, my lord. My lord, that report is also there. My lord, at page number 213 to 253, my lord. Page number 213, my lord, which is part of their reply, my lord, at page number 213. My lord, a detailed order was passed, my lord. What happened was this, my lord. May I submit this, my lord? Volume 2, my lord. My lord, what happened was this. May I submit this, my lord? My lord, what happened was the reason for remitting my matter back to the tribunal was, even after a detailed order in my favor, was that 4 matters were clubbed together and a common judgment was passed, although it were heard differently, my lord. It was for that reason it was remanded. My lord, on merits, I won the case before the tribunal, my lord, wherein I showed that I am a whistleblower, my lord. My lord, the judgment, my lord, of the tribunal may kindly be taken for a moment, my lord. Page number 95 may kindly be taken, my lord. My lord, for a moment, may kindly take page number 121, which is part of the earlier order of the tribunal. Would my lord kindly go to page number 121? My lord, these findings were set aside, my lord, by the tribunal, my lord. Clear, my lord, in a lengthy judgment, my lord may kindly take at page 121, my lord. Paragraph 55 of the judgment. Much obliged.
Oh, 6. 43. This is a case, my lord, in which I made a change of land use application in the year 2018. And land use has not been granted to me, my lord. If my lord would just take the reasoning of the learned single judge at page 38. Paragraph 18. May I read, my lord? It is not in dispute that there is no topographical or cartological error in the development plan. It is no one's case that there are errors or omissions made in the development plan, nor that it is the case of the petitioners that development plan does not indicate details of the plan or changes arising out of the implementation of the proposals of the master plan. The only reason why the change of land use is sought for by the petitioners is for better development of their own property. My lord would see on the paragraph 16, the court has reproduced section 14A. May I read, my lord? Section 14A, change of land use. It says any time after the date on which the master plan for an area comes into operation, the planning authority may, with the previous approval of the state government, allow such changes in the land use or development from the master plan as may be necessitated by topographical, cartographical, or other errors and omissions, or due to the failure to fully indicate the details in the plan, or changes arising out of the implementation of the proposals and outline development plan. 3 factors which the court has considered. Or the circumstances prevailing at any particular time by the enforcement of the plan. This is the 4th factor, my lord, which the learned single judge has failed to consider. If my lord would turn to page 204. It's the guidelines issued by the authority to itself, my lord. With the guidelines start at page 204, or rather the guidelines issued by the state government to the authority at page 204, proviso 4 of 14A1. My lord has that page. Circumstances prevailing at any particular time by the enforcement of the plan. This is the 4th proviso, my lord. Indicative list of cases that may be considered under this proviso. May I read subclause E? Any other case falling under this clause submitted by the authority with suitable justification may be considered by the government based on the merits of the case, such as lands in the vicinity of or contiguous to Gramtana or conurbation area, lands abutting roads or in the vicinity of roads. In such cases, it shall be ensured that the connectivity to the main road and is provided through an access road of adequate width. In an earlier round of litigation, my lord, they had dismissed my application stating that there is no such access road. The learned single judge was pleased to remand it to the authority for a specific inquiry into this, and a report came to be filed. I have 10-meter motorable road access to NH209. That report of the Tahsildar was placed on record. It was accepted by the authority. The learned single judge in the present case also accepted that report, my lord. That report has been accepted, if my lord would see, at page 27, para 5. That question is no longer open to the authority, my lord. There is a 10-meter motorable road access to NH209. Now the court only says that there is, because of the court considers the first three reasons and says the only reason I want change of land use is for the better development of my own property, which I'm not entitled to under section 14A of the Karnataka Town and Country Planning Act. My lord would also see page 232. This is the local land use map. I had three previous occasions shown it to the court, my lord. Page 232. The proposed land use analysis for the Harohalli conurbation shows that 0% of land in Harohalli is earmarked for agriculture. The court has misconstrued it as if 0% is earmarked for development. There was one other ground on which the authority had rejected my application, my lord, which is to... My lord, I have a right under Article 308. This is my property, my lord. There may be restrictions on the use of the property, no doubt. But the fact is, under their own guidelines, there is an access road to NH209, and my land is situated in close proximity to Harohalli conurbation. My lord is well aware that that comes within the greater Bangalore region. The entire area is being developed. In fact, BDA now is notifying a new peripheral ring road, a new airport in that area. There are developments that are happening way beyond my land, my lord. But I am 2018, I make an application. In the first instance, they do not act on it. So I come before the learned single judge and seek a mandamus. I'm granted a mandamus. Then they reject my application on the ground that there is no access road. The learned single judge finds that there was no inquiry ever conducted into whether I was not heard on that question. The learned single judge directs that the Tahsildar file a report. A report is filed showing that there is a motorable road access to NH209. Then they say that there is quarrying operations happening within a 100-meter radius, whereas the Karnataka Minor Mineral Concession rules stipulates that no quarrying activity can happen within 200 meters of any building area. Now, they then file an affidavit, my lord, saying that no, this all comes within it all comes within a 100-meter radius. That question is also looked into by the learned single judge. A report of the ADLR is called for. That report of the ADLR is placed on record, my lord, and that the court accepts. My lord would find those findings at page 35 and 36, paras 14 and 15 of the learned single judge's order. Then the court says the only reason I want change of land use for the better development of my own property, and does not look into the applicable guidelines with respect to the fourth proviso. The court notes that there is an access road. The court notes that there is the quarrying activity is occurring more than 200 meters away from my lands. My lord, in fact, the statute is very clear on that, my lord. It says, if I may just read, it says, provided that all changes are in public interest, the changes proposed do not contravene any of the provisions of this act or any other law governing planning, development, or use of land within the local planning area. And the proposal for all such changes are published in one or more daily newspapers, having circulation in the area, inviting objections from the public within a period of not less than 15 days from the date of publication, as may be specified by the planning authority. So the planning authority, having satisfied itself in the first instance that the change is not against the public interest, that it is not contraindicated by any other plan or law, takes out a paper publication, my lord. I pay the fees. The paper publication is taken out. I even have placed a no objection certificate from the Kagalahalli Gram Panchayat stating that they have no objection to issue granting civic amenities for the land in question. Thereafter, they don't act on my application, which drives me to the first round of litigation. Learned single judge issues a mandamus. Then the second round of litigation. In the third round of litigation, my lord, all the factors that they had relied upon to set aside 18 acres of land, my lord, I'm seeking to put up a residential layout in that land. In fact, I have e-filed 2 memos, my lord. That shows both of them were e-filed on Saturday. I've also filed physical copies. My lord, on page 42, just above para 23, the learned single judge says, may I read 6 lines from the bottom of that paragraph, my lord? It says, to buttress the same, respondent number 2, that is the planning authority, has also contended that if change of land use is permitted, and since the petitioner intends to form a layout for sale to third parties, civic amenities cannot be provided by the planning authority and or the municipal authority. At page 85, my lord, the NOC given by the Kagalhalli Gram Panchayat is on record. My lord, the planning authority never makes provision for civic amenities. It's always the Gram Panchayat or the local municipality. In this case, the Gram Panchayat has issued a no objection certificate stating that they would have no difficulty providing civic amenities to the question. Then in para 23, the court, my lord, all land in this country by default is agricultural land unless converted in a manner known to law, my lord. So therefore, the fact that if my lord would see, I have refiled a memo and I've also filed a hard copy. There are 5 orders or change of land use orders are produced before this honorable court. 3 in Gabadi village, 1 in Kagalhalli village, and the last in, my lord, Gabadi village is the village in which my lands are situated. Same village, they have granted 3 change of land use. In nearby village, Kagalhalli and Edamadu, they've also, they're proximate, my lord. If my lord takes the map at page 232, it becomes evident. Page 232. On the far right of the page, my lord would see Gabadi on the top right-hand corner. My lord? No, right-hand corner. Yes. 232. My lord would see Gabadi. Gabbadi. Page 232, my lord. Annexure S. Gabadi. So that is the village in which my lands are situated. 2 or 3 other change of land use applications have been allowed. My lord, the survey numbers, unfortunately, the detail is not very clear. But just above that is Kagalhalli village, my lord. I've produced a change of land use order passed in that village as well, and Yedamadu. My lord, unfortunately, this map doesn't have the detail to identify the survey numbers, but the survey numbers for which change of land use has been granted is survey number 30. My lord, so much material was placed on record, including change of land use applications in the taluk were placed on record. The ADLR. This says, my lord, Kaigarika Valayadinda Vasati Valayake, that is from industrial area to residential. It has been converted. And the next one says, Kaigarika Valayadinda Vasati Uddeshake, that is from industrial to residential. Third is also the same thing, my lord. Fourth is same.
My lord, the planning authority has to answer. They are purely asking in a agricultural zone. It's
My lord, it's not a
my
question
lord,
of
they have not
agriculture.
read the paragraph number 22, my lord. The reasoning is there, my lord, paragraph 20. State, my lord, R1, my lord. R2 is the planning authority, my lord.
Everyone else is the planning authority.
My lord,
The issue is that the planning authority is not appearing in the matter.
No.
My lord has heard the matter 3 times already.
No, my lord.
Planning authority has not been appearing.
No, my lord, he is a government advocate.
My lord, this is not.
Lord, the planning authority, my lord, Counsel Yogesh D. Nayak, he is a government advocate.
My lord, the contention that development cannot happen in isolation in an agricultural zone. It is not a notified green belt area, my lord.
Yogesh D. Nayak, my lord, he is a government advocate. In fact, I have informed him to come.
In fact,
one minute. He is assigned in Court Hall 28. I have also informed him to come, my lord. Matter is going on. Please, my lord. Affidavit is ready. That is what he has sent a message to me. Maybe he's held up in the court hall. Your lordships may kindly fix a date. I'll communicate him.
May I just make one further submission, my lord? My lord, I have that.
Please, my lord. I appear for R1, my lord. State 2 and 3 planning. Yogesh D. Nayak, my lord. Is assigned in Court Hall 28.
May I just make one further submission, my lord? The court had directed them to place on record whether any planning permission has been granted in the near vicinity of a quarrying area. I have e-filed a memo with a map, my lord, which shows that Bangalore-Mysore Infrastructure Corridor Area Planning Authority has granted planning permission for 3 residential layouts within close proximity of quarrying. But they comply with the requirement of the Karnataka. My lord.
Yes. He sent a message that affidavit is ready. Lordships may kindly fix.
My
Please.
lord, I don't mean to impose on the court, but I just may want to make one submission. With respect to the quarrying limit, the learned single judge has passed a definitive finding saying that query does not arise, that issue does not arise by virtue of the fact that the rules itself says 200-meter radius. And the ADLR's report, the Assistant Director of Land Records report, is on file, which shows that we are outside of that zone. So therefore, that question has been settled by the learned single judgment.
Query is not the issue, my lord. It is
date may
purely
be fixed, my
residential
lord.
zone. That is what the learner single judge says, my lord. Residential zone, as such, my lord, the planning authority would not provide any civic amenities or.
My lord, the planning authority would never, in any case, provide civic amenities. I'm not sure what how the respondents are making these submissions. A short date, my lord. Now, since 2018, my
layout has to be apparently approved by the planning authority, my lord. Gram Panchayat has no power to.
22/4. My lord, a shorter date, may I request me since 2046. Hearing number 46. Desh Kumar.
My lord, for the appellant. So we have a memo of submissions ready, my lord. Sorry. Don't pull it up, please.
In 47, what was moved for 47 in the morning? 47 was moved for
Both-
adjournment in the morning.
Both arise from an award of the,
No. 47 was mentioned.
who's my? Main file. Yes. My lord, the written submissions are maybe permitted. Synopsis, my lord. Please, my lord. My lord, and the appellant before my lord is a real estate developer. The respondent before the arbitral tribunal was the landowner, my lord. Both of us jointly agreed to appoint our respective arbitrators, who in turn appointed the chairman of the arbitral tribunal in order to adjudicate the termination of the joint development agreement unilaterally by the landowners. The arbitral tribunal held on all issues in favor of the developer, including holding that the termination was not in accordance with the agreement. And we had deposited, my lord, in 2007 and odd, 17.5 crores as a refundable deposit. Within 50 odd days, my lord, the landowner terminates the agreement, does not refund the money to us, and therefore we agreed to go for arbitration. The arbitral tribunal says that even though every issue is decided in your favor, we will grant you the alternate relief of compensation. So the tribunal granted a relief of 25 crores as compensation, in addition to refund of the sums paid along with interest. This, my lord, was taken up under section 34 by the landowners before the city court. The city court, my lord, modified the award because my prayer was specific performance in the alternate for it not being granted for compensation. Therefore, it's a composite single prayer. Whereas in the case of separate distinct claims, the court can bifurcate. Now the section 34 court, my lord, modifies the award by saying return the 17 crores and odd with interest, but the arbitral tribunal has not given adequate reasons as required under section 31 insofar as damages and modifies the award to that extent. I have come before this honorable court under 37 to the extent of saying that since the prayer is composite and since there's a finding in my favor for specific performance, therefore the award should have been upheld. My learned friend for the respondent is obviously challenging the award itself. Yes. My lord, there were two parts in the arbitral tribunal's award. One was to refund my money which I have deposited. Plus, the arbitral tribunal said that even though we have held insofar as specific performance in your favor, but we are granting you the alternate relief. We had sought for 100 crores as compensation. The tribunal holds 25 crores as compensation. No specific performance. Because, my lord, in a land where we have not yet been given possession, keeping in mind the long period of gestation, therefore we never challenged it. We said compensation is adequate. Now, the section 30, that was a refundable, it's a security deposit, my lord, to show compliance with the agreement. So we have deposited 17.5 crores. Tribunal says that all issues are decided in your favor and 25 crores as 25 plus 17. Yes, 25 plus 17 by the arbitral tribunal, whereas the section 34 court says 17, which is amounting, in my humble submission, amounting to modifying the award, which in Hakim's case and so many other line of judgment, Samudra's case, this honorable court has said, Supreme Court has also said, that you cannot modify the award.
My lord, they are 30.
My R30.
Section 34 code, my
It has
lord,
not modified.
goes to the extent of.
It has set aside in part. That is what has happened.
Yes. 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 We have to start arbitration again.
We don't know.
No, I'm saying. No. I'm saying, my lord, what would happen is, yes, ma'am. My lord, my difficulty is that when, my lord, in fact, recently also, the Supreme Court has held that the power under 34, there are certain specific grounds, which is not an appellate court. In fact, under 37, what the Supreme Court says, the power under section 37 is limited to those grounds under 34. So when we take that, my lord, that 37 and slightly narrower, I bow down to that. So when we look at that, my lord, the section 34 proceedings virtually replaces the reasons. My lord, in Dyna Industries case, what Supreme Court says is, let us say for a moment one issue, there's a finding on an issue and there's a judgment on that particular issue. However, the party aggrieved feels that there are not enough reasons given for that. What Dyna Industries says is that they can file an application under subsection 4 of section 34 to say that adjourn the proceedings under 34, let the arbitrate tribunal reconvene to give its reasons. No, even reasons, my lord. Dyna Industries says amiss. So they don't even file that application. Yes. Yes. That application is not filed by them. What my submission is that when such an application is not filed, no procedural errors are found. 3 judges of the Honorable High Court are the arbitrary, retired former judges of the Honorable High Court arbitrary. No procedural errors. They agree on jurisdiction. Could the section 34 court make a finding, which is?
And now it's referred to a larger bench.
My lord, irrespective what, my lord is well aware. Sometimes, my lord, just because the matter is being heard by the larger constitutional bench, the current law which stands, my lord, that
Propriety demands.
Lord, two appeals are filed by us, my lord. There are, my lord, totally 4 appeals. Company appeal, my lord, 132 and 133 are filed by us. '86, '85 is filed by them. My lord, 132 and 133 is filed by us. There is an application, my lord. They have now, my lord, started the execution proceedings. So, my lord, what is admitted, my lord, we would like to deposit. We don't want, my lord, to retain that amount. 17.5 crores is, my lord, an advance that was given. The contract would say it is interest-free. It is an interest-free. Now, what the arbitral tribunal has done is, my lord, levied interest. My lord, that 17.5 crores, my lord, we will deposit it in court, but they should not execute the award in the meantime, my lord.
My lord, we have filed for execution in 21. Our memo of calculation, my lord. Please, ma'am. Please.
What would be the?
Yes, my lord. I've, my lord, got a memo of calculation.
My lord, there is another aspect to this, my lord. Earlier, filing of 34 itself amounted to a stay. This was, my lord, in that era when this was filed. So therefore, my lord, appeal is a continuation of the proceeding. So therefore, my lord, that ground we always have. Subsequently, my lord, it was amended to say that unless, my lord, it is granted, it will not amount an automatic stay. These are all proceedings prior to that.
The amount,
Kochi Cricket Club is very clear, my lord.
So the amount under 17.5 crores with the contracted rate of interest comes to 56 crores 70 lakhs.
Yes,
Yes, yes.
yes.
My lord, 56 crores. Yes, yes. If it is excluding 34 judgment, it will come to nearly 110 crores. Yes,
Yes,
yes.
my lord. He
That's
gives
the contracted rate.
which is why, my lord,
110 crores.
which is why we have filed 2 appeals, my lord.
And their application. Give it. Please give it. Memo of calculation.
Yes.
Let's do what you are saying. Written liability is 17 crores on an interest which has been given by the arbitrator.
As per the contract, I may be permitted to pass on the memo of calculation. No, no, as I'm saying.
It says
my lord.
interest-free deposit, my lord. The clause says interest-free deposit.
No, no, interest-free deposit for compliance. For breach, it is 12%. My lord is pleased to see in around.
Can hear it today or on the interim or we can put it somewhere else?
My lord, in so far as interim, if they are willing to deposit, my lord, the application for stay. My lord is pleased to see the application for stay. It actually endures in my favor. It says, stay the execution of the impugned judgment of the commercial court. If that order is stayed, the arbitral award stays. Yes. They have not asked for a stay of the arbitral award. Their application is for the section 34 order. I will be very happy with this so that I will enforce the award.
We are seeking. Lord, we will deposit 17.5 crores. Lords may fix a date, my lord, only to secure his interest, my lord.
My lord, they are having so many fights. 25th.
25th.
My lord, could be taken up even, it's only 1 hour each of Monday, my lord, if my lord. Please, my lord, please.
He's saying 17.5 crores and the whatever the interest which has been.
Yes. Yes.
Say the execution.
Because it is interest, my lord, free. Yes. You decree, my lord, 50% normally, my lord. So it comes to the same thing, my lord.
Money decree is 100%, my lord. Supreme Court says. No, no.
We'll deposit the, my lord.
As of today, whatever is there.
Sir?
75%. We will stay.
I'll take instructions, my lord. I'll take.
You are giving me 46.2.
Yes, please. All.
Then say that as for the deposit of the
Yes, ma'am. With interest.
Yes, please.
Yes,
my lord.
it's one agreement, my lord.
My lord. 2 weeks.
2006 it was paid. Interest.
Great. Grateful.
My lord, we may be permitted to file the memo of submissions and authorities. ma'am. Grateful.
Passed over matters. Serial number 10.
Preparing for the appellant in this case, my lords.
Yes, my lords.
My lords stated that there are two petitions, my lords. Two RFAs, but only one RFA is listed, my lords. So second,
My lords, one RFA was filed 446 of 22, my lords. That was dismissed for non-compliance of office objection. Again, the appellant had filed an IA for reinstalling that. Again, it was reinstalled as 452, my lords. Again, that was dismissed for non-compliance because he had some health reasons. That's why that was dismissed. Now,
no, my lords. 446 of 22 and 452 of 22.
yes, my lords. Yes, my lords. Non-compliance. Subsequent.
That's one submission. It was not dismissed for non-compliance, my lords. The IA for recalling was dismissed, my lords. Non-prosecution. The first time, my lords, they have filed IA 2 of 22.
My lords? Yes, my lords. Yes, my lords.
Let's later, well, subsequently, they filed IA number 2 of 22 for recalling minutes.
This order. 446 is the finality.
Yes, my lords.
That's why we filed.
That's why we filed 452,
No, my lords.
452, my lords.
Yes.
Yes, my lord. 23.
Read that order.
21.
21st.
21st July 22 order. hai. Order. Not check ಮಾಡಿ Yes, my lords. My lords.
Because the rental arrears is about 30 lakhs and odd 2 years back. My lords, they did not appear because the Honorable Court insisted on settlement, my lords. It was a deliberate in.
My lords. Yes, my lords.
That's one submission.
My lords. Yes, my lords.
See 23 to 2023 order. We have that order.
No, my lords. I don't think about that. The application is filed in both appeals to recall order dated 21/7/22, the court notice para 4. The court has granted several opportunities to enable the parties to amicably settle the matter. Despite the same, the present attempt appears to be dilatory tactics. Hence, appeal is dismissed for non-prosecution. These two appeals by tenants and both the suits are for ejectment had been decreed. Srimati Bharti Patil, learned advocate for the appellant, submits that the possession has been delivered to the landlord. Arrears of rent has to be calculated. She seeks times to file a memo of calculation. As of now, these appeals are dismissed for non-prosecution. We find no grounds to recall the order 21/7/22. In circumstances. Yes, ma'am. Yes, my lords. My lords, the appeals were dismissed for non-prosecution, my lords, and some submissions I'll make before this honorable.
Only filed in 452 today.
Yes, my lords. One short date. Sort of confusion, my lords, on short date, my lords, so I'll file that. I also for recalling.
In that main appeal, we have already filed an application that is also disposed for non-prosecution. That's why we.
My lords, my name may kindly be deleted because I've given NOC in the matter, my lords. Please, I will intimate, my lords. Please, grateful, my lords.
10-6.
serial number 14. 14.
My lord, in this. This is regarding forfeiture of gratuity, my lord.
Before that, I want to make some small submission. When the supplement bank has challenged the order passed by single judge order for payment of gratuity of 6,84,000. But during that, when that order was passed, there was a special CC was pending. In special CC, yes, that is what I am submitting.
That is what he is also telling, my lord.
That is what my submission. Now I am convicted. I am filing an appeal against the order of conviction. Yes, that is what I am telling. The conviction amounts to moral turpitude. So as of now, I am not in. No, my request is to allow me to withdraw my writ petition filed earlier.
Earlier it, no, set aside that giving the liberty.
And you give liberty.
In case he succeeds, he can make representation to the bank. That is all.
If I am acquitted, I may be permitted to. Liberty may be given.
Yes, that is what he is also telling, my lord.
But there is one thing. Why only a conviction? Even a loss cost to the employee is a ground to report the claim.
But no,
No, in special
in this
CC
case,
order.
my lord, they are not, in this case, bank has was, they have said that page number 51. Only because it's a moral turpitude, he has done all those things, only moral turpitude.
No. Okay.
Loss sustainable.
No.
My last, my lord, at that time, 2008, there was a 9.22 crores. Then this parties and all, because of the CBI cases and all these persons were party, they paid so much of amount to the bank now, that only this some amount may be remaining. That is what my lord said. No, my lord, more than 6 lakhs only, my lord. Yes, there is no issue, my lord. In this.
My point is in that special CC, the honorable judge had said there is no monetary loss to the bank. That is there.
What were the charges against you?
Charges accommodating the customer.
As fabric, that on the base of the fabricated document, given the loan, 300 loans.
But special judge has confirmed that there is no loss to the bank because before that judgment came, all the amount was recovered.
See the charges which have been made against you. You see those charges. The charges are made to the law. Shows loss to the bank.
No, but in the final order, there is no, they have mentioned that there is no loss to the bank because total amount is recovered. That special judge in special CC 41 of 2012, where he is convicted. No.
No, my lord, this is judgment delivered day for yesterday. Conviction. No, same thing, my lord.
Special judge only.
Same court.
Yes, he has come to the conclusion that there is no loss to the bank. That is why I am seeking liberty to file if I am acquitted.
Oh, my lord.
He says, there is a conviction today. So he will come with that moral turpitude.
My lord, our forfeiture was gratuity only for moral turpitude. We have not told last. In that. Yes, my lord. That will then he has to make the representative to the bank. That is what he is asking liberty. That is okay, my lord. Yes, my lord.
Staying, set aside the judgment of the single judge. And in the eventuality, on an appeal, the conviction is set aside. Liberty would be due to make a representation.
Yes, ma'am.
That is what. Yes, ma'am.
Intra-court appeal is to an order dated 7th September 2023 after the petition of April 2011. The divider was submitted and allowed the petition filed by the by stating in paragraph 9 and full stop. During the course of hearing, we have been informed that the appellant has been convicted by the criminal court.
Yes, ma'am. Judgment is here, my lord.
That will make it so and so. That will make it so and so. So, the other of the members, single judge. Single judge for the release of the gratuity in favor of the respondent. Cannot be cannot be sustained. This aspect is also acknowledged by the learned counsel for the respondent. It only states that the eventuality, the respondent files an appeal before the order of the sessions judge dated 6 February 25 in special CC number 41 of the contract, and the respondent is exonerated of the charges, liberty being granted to the respondent to make a representation to the bank for the release of the gratuity. The learned counsel for the appellant has no objection insofar as the situation made by the learned counsel for the respondent. The order of the single judge make a choice of set aside in the eventuality the appellant, the respondent is exonerated in an appeal. Indian appeal will be filed by him against the order of the criminal court dated 6 February 2025 in special CC 41 of 2022, liberty shall be with the respondent to make a representation to the bank for the release of the gratuity. The same shall be considered by the bank and pass necessary orders in accordance with. If
15, Maitrey Krishna.
Yes. What is the issue which remains here?
Please, my lord. My lords, the issue is only this, my lord. It's not on 9A. The issue is whether they could have unilaterally changed the terms of the settlement through 9A. They have done it through 9A. Once there is a settlement that governs the methodology of calculating leave encashment, whether any one party could unilaterally change the terms of that settlement, my lord. Here what has happened, this is a settlement that has been binding on them from 86 onwards. They issue a notice saying they're terminating that settlement, and subsequently they say that they issue a notice under 9A saying that they're changing the methodology. Even on termination of the settlement, until that settlement is replaced by another settlement or an award, the terms of that settlement would be binding on those parties. Admittedly, my lord, there is no other settlement, nothing has replaced that settlement. Please. Yes, my lord, even if there is a termination. In fact, my lords, one of the documents that I have produced, it is a office memorandum issued by the ministry where they specifically say it will be made 30 days if there is nothing else governing it. My lords may recall that it is in respect of the methodology of leave encashment, whether it's 26 or 30 days. Please, one of the documents, my lord, specifically provides that, I'll just read it out, my lord, for a moment.
Lord,
If I may just read, my lord.
the writ petition has been dismissed not on merits. The writ petition has been dismissed because parties were in conciliation proceedings. Conciliations are closed. Now, my lord, it is before the government for making a reference. Therefore, the learned single judge rejects the petition on the ground of maintainability, saying you have an alternative remedy. Now, justification or otherwise, whether the settlement can be unilaterally altered, what are the reasons, whether the government directions are binding or not, these are all matters to be gone into by adjudicating tribunal after parties are put on, yes. No, my lord.
Yes,
no, my lord.
because,
That runs,
my lord, because
that runs counter to the provisions of the Industrial Disputes Act.
That is
Therefore, my lord, that also, my lord, will have to be gone into by the tribunal, my lord. That also, my lord. Now, the change has come into force. Now, my lord,
let me just submit this.
1 minute. The
Please.
tribunal, my lord, after adjudication, if it finds that the change is not justified, it has the power to grant relief from the date of reference or from the original date.
The question.
Yes.
Please. Yes.
Now we have come to 30 days.
If they were at 26, they've gone to 30.
Yes.
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 Yes, yes. And in fact, sorry.
There can be a composite reference.
Yes.
On this aspect also.
Yes.
Pending award, can there be a change in the computation of the leave encashment? If the court or the tribunal where a reference is made will have two kinds of reference or two parts of references. One, pre-reference period or pre-award period, and second, post-award period.
Yes.
That if the tribunal says till the award comes, the old conditions must hold the period. That means it would be 26 days and you are entitled to leave encashment on 26 days. Post-award, if the court comes to a conclusion, this is justifiable, this change of service condition, then it will hold the field post-award. So what do you have to say on?
In fact, my lord, on this, I'll just
Section
respond.
Section 10(4), there is a provision, my lord, where the union can file an application seeking interim relief. Court can decide that.
My lord, I'll answer
When a matter is
question of
referred
this
for
court, my lord.
adjudication.
I'll just answer the question that was posed. Yes, my lord, please.
Yes.
My lord, insofar as the question as to whether a settlement can be unilaterally changed or not, that position is settled. What would need to be, what the tribunal might, if it goes to that, might need to look at is whether there is a need for the settlement to be altered. If they are saying that the settlement is terminated and we want to change those terms of the settlement, whether the alteration would be fair, would it be justiciable, would it be something that was required? Please. No, my lord.
Even your plea.
Yes.
That will award comes.
Please.
Would also be reviewed.
My lord, I'm just responding to that. The question, my lord, if I may frame the question in this way, the first part would be what my lord is saying is that till the award comes, till an award is passed, whether it would be 26 days or 30 days would also be a question that would be open to the tribunal to. Whether the award could be the settlement could be changed. Please, my lord, please. So with that question also could be looked at by the tribunal is the question that is being asked to me. My lord, if I may just answer that, the question as to whether the settlement is binding, whether it could be terminated unilaterally is a question of law, It's a pure question of law, which is in respect of which the position of law is settled, that it cannot be done. The question whether, my lord, a settlement is akin to an award. Can an award or a settlement, and this is an 18(3) settlement before the conciliation officer, can that be unilaterally changed? That is a question of law in respect of which the position of law is settled. So therefore, the only question that would have to be determined by the tribunal is, given that the conciliation proceedings failed in respect of the change of this number of days, that whether it should be changed from 26 to 30 days, that is something that will be looked at. But please, my lord, that would be something that would be looked at. But in respect of so therefore, my lord, my only submission is that insofar as the first portion, what my lords was saying, that there would be two portions if we are to look at it. That portion, it's a settled position that it cannot be changed. Yes. My lord, the prejudice to me, I will say, Ahmed. Yes.
You surely rely upon the same material which you intend to rely upon here. On a pure question of law, the issue has been decided. In such kind, the award passes, the change of whether the settlement could have been unilaterally changed is decided. You are entitled on the basis of 26 days. That issue is a pure question of law. So what we are saying is, we are entitled to that amount till such time the award comes. So you continue to pay. What we are saying is, even the tribunal, if it agrees with you on a pure question of law, cannot come to a different conclusion except that 26 days. So that need to be paid till the award. Right? What you are saying is this, we will tell you what you can say. You will say that if this position is accepted by this court by hearing this appeal, purely till that award, everyone would be entitled to the leave encashment on the basis of 26 days. It is post-award, if it is ultimately reference is decided against you, that you will be entitled to compulsory leave encashment on the basis of 30 days. So in the interim, you will get the benefit of 26 days. They may be mutuality. Many of the people may retire. They may get leave encashment on the basis of 26 days. You don't, possibly you can argue. We don't know what will be the position after the award comes if both the aspects are referred to. That can be an argument.
Please, my lord has answered this question better than I could have. But that is the crux, my lord. I am only entitled to accumulate a certain amount. Please, my lord.
If your lordship
My lord
wants
to
to
decide it.
no, my lord, then the issue would be, if your lordships are going into the merits of the case, then your lordship would be entering into the merits of the case. Yes, my lord. Yes, my lord.
That there is a dispute.
My lord, yes. Yes, my lord.
What you think argued is 26 days is our right based on the settlement.
Yes, my lord.
You have changed the terms of the settlement.
Yes.
They say unilaterally, but whether that settlement need to be given, whether the change in the settlement need to be given effect to is a subject matter of a reference. Pending that, till such time this issue is decided, there cannot be any vacuum. There cannot be any vacuum.
No, my lord, there is no vacuum because I have implemented the change. Now they are getting it at 30 days.
My lord, that
Now,
cannot.
I'm sorry, 1 minute, please. I've changed it, it has come into force.
My lord, that is through the 9A notice.
1 minute.
My lord,
But
that is precisely
now, my
what I'm
lord,
saying.
I think my learned friend should permit me to make
My
some.
learned friend has.
All right. Yes, my lord, your lordship will find that. Yes, my lord. Annexure B at 74. Yes, my lord.
My lord, this 27/12/2023.
23, 27/12/23.
That is what I had impugned.
Yes, my lord. That is what is
That is
impugned.
what is impugned. My lord, immediately thereafter. That is what I have impugned annexure B. That is what I have challenged. My lord, I had immediately approached the court. No,
There was no
my
stay.
lord. It was heard immediately. There was no interim order at that time. It was
Yes.
heard immediately.
It was heard and then it was held, it is not maintainable because conciliation had been concluded and the matter was before the government for reference.
That very I'm sorry. Yes.
That to now, situation we are, how we are seeking is something status quo ante.
124.
We will give back the position that was existing before 2023. That's the effect.
My lord, I had impugned the communication whereby they attempted to do something which is impermissible.
Yes.
Position as is existing before 2023, yes or no?
My lord, at this point of time, my lord, yes, I am asking. My lord, my prayer, if I may just, yes, that my prayer is this. My prayer in my writ petition was this, my lord. I had sought for the quashing of the communication dated 3rd August 2023, where they where they issued a notice of change. Then I sought, and my lord, thereafter there was a conciliation that was raised. The conciliation that was raised at that time, they did not make any change. Then I had sought for I have impugned the communication dated 27 December 2023 in my prayer. And I have sought for direction so that to ensure compliance with the memorandum of settlement dated 19th August 1988. May I put it this? I'm sorry, my lord.
It's not come as
not made.
In fact, first prayer, if your lordship says,
Since it's not made.
my lord, first prayer, if your lordship says, is to quash the notice that I issued for change under 90A. How can that be done?
My lord, the 9A, it is very simple, my lord. This is all my submission is, if I may just summarize my submission. Once there is a settlement from 1988 onwards, that settlement is binding on both parties until it is replaced by another settlement. My lord, because my lord said that I'm asking for my prayer is effectively for a status quo ante. Yes. What happened was that they issued a notice saying they're going to make this, they're bringing this change in. As soon as that was done, I had approached this court saying that it's being done immediately. If at all they have to make any change, it can only be done depending on what the outcome before the tribunal is.
You are on a different situation. we say that 23 must restore that. Something which has been put in place.
Yes, yes.
Which has been put in place. Be rightly or maybe wrong. Has been put in place. Now with this, what you are seeking is, we put back into the place, to the position which was existing prior to 23. Which henceforth, it should be computation on the basis of 26 days. Which in law, maybe possibly, suppose you may be able to convince this court very well it is permissible. But in appeal it says no, it could not have been till such time that reference has been made and reference has been decided. Why we are saying is, if you succeed, you will get back from a bad day.
Yes.
My lord,
Yes.
please, my difficulty is this, my lord. My lord had also said, there are people who are going to retire. I am only entitled to accumulate leave up to a certain extent. So then, therefore, I'll have to encash certain leaves because I cannot accumulate beyond a point. What my submission would be is this. Yes, my lord, they did issue that notice in 2023 December. And then thereafter, since my writ petition was dismissed on the grounds of alternate remedy, effectively that has come into force because that has not been set aside. But the issuance of that communication itself is illegal. And it is illegal and it's contrary to the position of law that is well settled. It's not that there's any disputed question of fact, my lords.
My lord, may I make a submission, my lord? May I make a submission, my lord?
My request would be if my lords could hear the matter. That would be my request. If my lords could hear the matter, any date may be fixed. My lords had already heard it to some extent. But my only request is,
My lord, it is already in place. What I would submit is, my lord, your lordship may observe that, my lord, ultimately, when the award is passed, party should not claim equities. I'm ready, my lord.
My lord,
otherwise, what happens is this: if ultimately I succeed, my lord, payment that is made to employees, I can never recover back. How can I recover back? Already I have paid around 6 crores more. That is the position, my lord. I will give an undertaking. If I lose, I will pay the money to all those, even if they have retired. Yes, my lord. Yes, my lord.
And
That is
as
what
of
I am
today, my lord,
submitting.
there's no reference made even.
Yes.
Please. Yes. Lord, if I don't succeed in this.
Yes.
Yes.
Till that award comes.
Yes.
We don't know 4 years, 5 years, 6 years.
Yes.
Then what will happen?
My lord, the award when it comes, it can only come into force from then.
Yes.
That is the point, my lord. But that's a fact. That is the law.
Can't have
That's
it
what
both
the law
ways.
is. My lord, I'm having it only one. Actually, my lord, I have it. Yes.
Of the two eventualities, which is a better eventuality? Reference made, you succeed, you will get from a bad day. Reference made, you don't succeed, the direction is to give the benefit in terms of the old settlement, they succeed. They say, see, look here, we are out of pocket despite our action having been upheld. What's your point? What is that seems from you?
So my request would, I understand. Please. My lord, may give any date on this matter. Because, my lord, because until then, whoever retires, and until then, I have in fact placed the calculation, my lord. I will show my lords. My lord, I will show my lords the difference. I have placed on record a calculation of giving one example.
My lord, what they do is,
My lord,
every year
if I
they
may
are
just
permitted,
finish my
my lord,
submission, my lord.
10 days.
My lord, effectively, if one of the workmen who is retiring in April of this year, my lords, if their leave encashment is, the difference is seen.
30
Yes, my lord.
days.
Yes, the difference is 2,53,900. My lord, the entire leave encashment, if he's retiring, for instance. Yes. Yes. The difference is 2,53,000. Yes. The
excess amount you would get on the basis of 26 is this 2,56,000.
yes, Manoj.
Excess.
The excess. And this is for one person who's retiring in April. I've taken a case of an actual workman.
You know, I will also file the calculation below.
19.3.
But what happened to the wine? Reference is not to
Not, in fact, my lord, what has happened
It has
is,
not been. They are a party, my lord.
my
They are a
lord,
party.
my lord, may I make one more submission? My lord, this is pan-India. HAL, my lord, has 9 centers throughout India. My lord, previously what happened was, without terminating the settlement, 9A notice had been issued. Then, my lord, every center, Nasik, Bangalore, Delhi, Hyderabad, in every center, the union, the very same union, there is a federation. They raised a dispute and they were all referred. Now, because this is of national importance, because several other units are involved, now, my lord, the government withdrew all those references and then made a reference to the National Industrial Tribunal, a special, yes, that was constituted. Then, my lord, that was, that the award was passed because, my lord, in the meantime, we withdrew the 9A notice because we had not terminated the settlement. Subsequently, we have terminated the settlement and issued a fresh notice under 9A, which is now in place. Now, my lord, reference has been made. In Hyderabad, there is a reference which is pending. In Bangalore, it is not yet been referred. Therefore, my lord, ultimately, this has to go. Yes, my lord. Yes, my lord. It should go to the National Industrial Tribunal, my lord. Yes, my lord. Yes, my lord.
No,
No,
my
my
lord,
lord,
central.
Central.
It will have to be before, the conciliation was before the central government.
But they are not made parties here, my lord.
They are, my lord, just one aspect may be seen. I'm sorry, my lord. When the matter was before the tribunal, before the National Industrial Tribunal, in fact, the termination had taken place much before that. It's not that it had taken place subsequently. The dates are there. It's part of the award. In that reference, my lord, what they in fact say, and it's recorded in that reference, that this, I'll just read out that one line, my lord. At the time of hearing, learned counsel, Ms. Geeta Raju, this is who's for the HAL, submitted that leave rules 1988 for its workmen issued under personal circular number 582, dated 15 July 1988, is still in existence as there is no fresh settlement. My lord may see, as there is no fresh settlement between the management and workmen union for modification of the same. The workmen who are governed by the HAL leave rules 1988 are still enjoying the leave encashment benefits as provided therein. Therefore, thereby she passes for passing no dispute award.
Yes. Now,
Since
because
the
we had
authority,
not issued 9A. Yes.
Since the authorized representative of the management who was present along with the learned counsel, Ms. Raju, submits that leave rules 1988 is still in force and no modification as intended by the management in the year 2007 has taken place till date, this tribunal holds the reference is not maintainable as there exists no cause for raising the dispute as referred by the Ministry of Labour to the tribunal for adjudication. So the submission that was actually made, which was made before the tribunal by the management, was that there is no settlement that has taken place subsequently. So therefore that settlement will be in force.
Yes.
But my lord, what has happened? My lord, prior to that, in fact, it records. Yes.
Yes.
It brought about another notice.
Yes.
My lord, what was challenged before the tribunal was a notice under 9A.
19.
Very well.
Please, please.
Yes.
19.3.
Obliged.
Grateful.
16. 3. 16. 23, 4. 24.
Okay, for the appellant. She sought for a correction, my lord. The matter was remanded to the Karnataka Real Estate Appellate Tribunal.
Rectification can be done, my lord. I have no
So
objection.
while transferring, my
It
lord, they are
is,
not giving us the bank account details. No, my lord, when we asked the tribunal to take up the appeal for admission, that was, my lord, after it was started functioning, my lord, recently about 3 months back. Yes, my lord. Then, my lord, we sought for transfer. They did not give us the account details because appellate tribunal name was not mentioned.
Yes.
Yes, my lord. Paragraph number 3, my lord, internal page 3, instead of RERA authority, my lord.
Please. Respond number 1. my lord. Beneficiary, awardee, customer, yes.
The application is that the application is that the word RERA authority is recommended in 2023.
Para 3, my lord.
Be corrected to me after real estate appellate.
Yes.
Will the council appearing for the respondent number 1, that is Prakash
SD.
has no objection.
No, my name is H. Malanod Prakash. SD is the party name, please.
Hearing for Prakash.
Right, please.
Has no objection. As sought. In paragraph 3.
Paragraph 3, my lord. That is transferred to the RERA Karnataka Real Estate Appellate Tribunal.
Italics parenthesis transfer to the RERA authority. But why does it say fixed deposit till the disposal before RERA authority?
No, that
Again,
is
that
how
also
that
should be-
confusion erupt, my lord.
No, one is,
RERA authority is different and appellate tribunal is
yes,
both
yes.
the places, and the already amount deposited to be transferred to the new name.
In substance, as deposited the entire stock, the amount is deposited in deposit before the score can be transferred to real estate appellate tribunal.
Karnataka Real Estate Appellate Tribunal.
Fixed deposit till disposal of the case before the Karnataka real estate appellate tribunal.
Yes, yes, yes.
Okay.
And direction for the speedy disposal, my lord, since it relates.
Deeply.
Table number 29, Vijay Narayan.
Yes.
Place on record the list of document, also synopsis and last.
My lords may fix date on next Monday, my lords, kindly. My lords, next Monday. My lords, next Monday, if the date may be.
It's not, so we'll give you a convenient date. You open the date, you do?
The 20th March.
My lords, March. My lords, executing court has a hearing date on next 17.
18th of March, nothing is
18th
happening there.
instructed me. My
That is
lords,
pending from 2011, my lord.
My lords? My lords, no, my lords, I want February. My lords, just one request.
Yes.
The executing court has this matter listed on 18.3. Executing court in Dakshin Kannada, they have the matter listed for executing. The purpose of the purpose of hearing is sale. My lords, my lords.
We have filed the execution that is pending from 2011. That is now it is for ADLR report. That is we are pending from 2000. That are
subject.
Yes, I will take a.
My lord, subject to outcome of
That
this
is pending
proceeding,
from that
no
state,
precipitative
pending from
action
long
in the
date.
state of hearing.
I will take
My lords,
adjournment.
my lords, nobody know. This is still contingent.
Yes, I will take adjournment next date of hearing, that is 18/3.
My lords, no
One.
precipitative action, subject to the outcome of this proceeding, at least in next date of hearing.
No, no, no. Next date,
But my lord, if,
yes, madam.
my lords, if I may beg to make grateful.
23.